Yeah, we'll have it on 18th.
18.
Yeah.
In item number 4 and 5, wait for adjournment. My senior counsel, because I was swelling for allergic reaction. Already informed. Treatment was going on.
Sharma,
Sharma, yes.
oh, he wants an adjournment.
Yeah.
When?
Next 14 November. With counsel with the opposite.
Is it okay?
Yes, yes.
Okay, on request made on behalf of A. Sharma, learned counsel for the petitioners. List the matter on 14th.
Hello.
May I please, my lord. I beg to mention item number 7, my lord.
Hmm?
My lord, I beg to mention item number 7.
Huh.
My lord, this matter may be adjourned for the day, my lord, and matter will be listed on Friday, my lord.
No, you are Mr.
J. Islam, my lord.
On request made by J. Islam, learned counsel for petitioner. List after 1 week. Yeah. Yes.
On Monday, my lord.
1 week. You are making the adjournment. I'm not.
Right.
Lordship, I beg to mention item 19, Lordship. Lordship, this matter will be taken in the month of December.
You are for?
I am for petitioner, Lordship. On behalf of AK Datta, Lordship.
On behalf of?
AK Datta, Lordship.
On request made on behalf of AK Datta, learned counsel for the petitioner. List. After 2 weeks.
12 December, Lordship.
Okay, on 12th December.
Obliged, Lordship.
May I please, I beg to mention for listing, my lord, and review petition, my lord.
Review.
Yes, my lord. Last posted on 27/8.
27/8. Okay. 14th.
Another is a read petition for admission, my lord.
Okay. 18th.
Obliged.
May I please, your lordship? Therefore, listing lordship, meta relating lordship, pay scale lordship. On 14 lordship.
20.
May I please, your lordship? Lordship, I beg to mention for listing of a matter for orders. The matter pertains to non-payment of arrears salary.
13th.
30?
13. 13.
May I please, your
Oh.
lordship? Your lordship, I beg to mention item number 11. Your lordship may kindly adjourn the matter for today.
You are appearing on behalf of?
RC Saitya, sir, petitioner.
On request made on behalf of RC Cycle.
Your lordship may kindly fix it for
I'm not
1 week.
fixing dates. List after 1 week. Yes.
Obligation.
Maybe listen, Lordship. Lordship, kindly allow this two matter for listing, Lordship. Lordship, this matter last posting on 19/2/2024, Lordship.
Oh. Okay, 20.
20. Obliged.
Wait, please. No, I beg to mention item number 12, madam.
Oh.
This matter may be taken up next week, madam. This is a writ petition prepared by the state, madam.
Oh, by the state.
Yes, madam.
Okay.
Next week, madam.
Request made by NG Katanya. Then the Standing Council Elementary Education.
Yes, madam.
Appearing for the petitioner. List after 1 week.
1 week, madam. Obliged.
This may be fixed, Lord. I'm for the petition.
Yeah. Huh?
Oh, sorry, I'm for the respondent.
You want the date fix?
On 12.
Yeah. 12 or 19?
19. Okay, madam, 19.
19.
Oh,
May I please, Lordship? Lordship, beg to mention item 15 and 16, Lordship.
Yes.
We have taken consent of the other councils.
Hmm.
Matter may be adjourned, Lordship.
You have 40?
Mr. ARPR, Lordship.
Item?
15 and 16 tagged items.
Oh.
We are the petitioner in item 15, Lordship.
You've taken consent?
Yes, Lordship, we have taken consent.
Okay, on request made on behalf of AR Bhuyan, London Council for the petitioner. In WBC 1361 of 2019. When do you want?
The 3 weeks.
Is the matter of 3 weeks.
Obliged, Lordship.
Madam, may I please, your lordship, with regard to item number 8, my lord, the consent of the petitioner, my lord.
Item?
Item number 8, my lord.
8 and 9, ma'am.
9 is tagged, my lord. My lord, it may come after 2 weeks, my lord.
We are appealing for?
I'm respondent number 5 and 9, my lord.
5 and
Boroland
9.
University, my lord.
Huh?
Respondent number 5 and 9, Boroland University, my lord.
But item number 8, I am appearing for the petitioner.
Item number 9, I am for the petitioner, my lord. And item number 8, I am for the respondent number 8, my lord.
Okay.
Can it be on 26th of this month, my lord? All agree, my lord.
Okay, on request made by Mr.
VK Borwa, my lord.
Vicky Bora, legal counsel appearing for the standing counsel.
Council, my lord.
Legal counsel appearing for the Boroland University. List the matter. When do you want?
26 mile.
26 now.
Highly obliged, lordship.
May I please your lordship? Lordship, I beg to mention for listing of a writ petition, for orders, lordship. On 18, lordship,
20.
20. Okay. Deeply obliged.
I pray for listing of a content case,
Yes.
for listing in the next week only. It's of 2016 matter.
18.
18. Obliged.
May it please your lordship, I beg to mention item number 10, your lordship. An additional affidavit filed today may be brought to the court, your lordship. Your lordship allows.
Order matter.
Yes, yes, your lordship.
Okay.
Much obliged.
May it please the lordship. Lord, I may be allowed to move an urgent matter.
Wow.
My lord, the urgency is that a departmental proceeding was initiated against me. IOPO appointed, proceeding started, inquiry started. I participated in the inquiry. I submitted an application for allowing me a defense assistant, which I am legally entitled. But the disciplinary authority, my lord, refused my legal defense assistant and continue with the departmental inquiry. I am compelled to cross-examine the witness myself, my lord. Very limited prayer, my lord. I am praying for stay of the DP till you allow me to engage the defense assistant. my lord.
We can have it tomorrow.
Actually, my lord, tomorrow the date of inquiry has been fixed and the communication by which, my lord, the inquiry has been fixed tomorrow, that was given to me yesterday.
Okay.
If possible today, my lord, it would be very kind, my lord.
All right.
Highly obliged.
That is a lordship.
Hmm.
So I beg to mention for listing on writ petition, my lord. 18 can be done.
20.
20. I have a similar pair for another writ petition, my lord. 20.
That will be 22nd.
Most.
May it please, your lord. My lord, this matter pertains to, my lord, candidate, my lord. NET UG selected yesterday, my lordship has directed to appear before the authority before 5, my lord. A list has come up, my lord, at 11 o'clock, my lord. My name is not there. 3 authorities have declared, my lord, I have 40% disability. Only the question remains that whether, my lord, it can be, my lord, whether my disability comes in the way of my admission, my lord.
Oh.
And then, my lord, when I was examined, my lord, the examining officer, my lord, she informed that, yes, your disability, it can be brought down to, my lord, below 40%. That I was informed, my lord. I don't know what is there on record. But, my lord, today is the last date, my lord, and this girl, my lord, she is, my lord, evidently having 40% disability. Only question, my lord, whether her disability comes in the way of her admission, my lord. It is the question
That
of
order was already passed yesterday.
yesterday, my lord. New cause of action has arose, my lord. Yesterday night, my lord. That is why, my lord, I am praying.
Let it be listed. Otherwise, my lord, seats are filled up because, my lord, after the report, the DMA has said, my lord, uploaded the seat, my lord, for online counseling. It has been filled up already because all those, my lord, vacancies, my lord.
Because, well, my lord, this is a beneficial legislation, my lord. And,
No,
my
so
lord, I have
see,
been declared, my lord, 40% disability, my lord. That is, my lord, all the authorities have, my lord, accepted and examined me and found me, my lord. Then why, my lord, 40%, my lord, exact 40%, my lord, by using, my lord, special aids, my lord, it has to come, my lord. This is normal, my lord, circumstances. It has to come down, my lord. And, my lord, the officer who examined me, my lord, informed that, yes, my disability.
So what
my
do you
lord,
want?
I pray, my lord, before unlisted, my lord, before 12, my lord, if it is
Yes,
possible,
yes,
I have.
Let it be before 12, because I will place the inspection.
Have you filed it?
I filed, my lord. Filed.
Okay.
Filing
before-
number and
before
everything.
12.
I'm highly obliged, deeply obliged, man. Deeply obliged.
If it is not before 12, then this court can't help you.
My lordship.
It has to come before 12.
Yes, my lordship. Before
I've
this.
got the
court.
report also, but I will place it.
My
Whatever
lord.
matter is listed, I will
My lord. Deeply obliged, my lord.
May I please, your lordship, I beg to mention for listing, my lord, any data next week, my lord.
Yeah, 22nd.
Most.
Well, similar pair for listing of a contemplation.
Yeah, 22nd.
26.
In concern of the other parties, I beg to mention item number 14, my lord. Here, my lord, equiprocesto during puja vacations, a brief was misplaced, my lord. So 10 days time is required. It may become in 19. 14 item.
Okay, on request made on behalf of AK Prokestal and counsel. This after 2 weeks, I'll give you.
That may be fixed, my lord. Otherwise, 19 is
You are adjourning the matter
my lord. Yes, my
after 2 weeks.
lord.
In respect to item number 11, I am for the respondent number 6, my lord. Here, my petitioner's counsel, Mr. R.C. Saikia, he called me last night, my lord, that he will take an exam and it will be mentioned in the morning, my lord.
That was
My son
mentioned.
junior, my lord.
It was mentioned.
Mine's 11.
Uh-huh.
Oh, I was noticed. Oh,
Item 1, 2, and 3 of daily leave.
May I please, Your Lordship. My lord, there are 3 cases. I request your lordship to take up 4998/24, my lord.
4?
4998/24.
Yes.
Yes. Now, here, my lord, this case, before entering into the documents, my lord, the writ petition, my lord, here is a case relating to provincialization of the petitioner.
Oh.
Now, my lord, the entire issue, it rests on a, my lord, provision of law under the Provincialization Act of 2017, that is Section 3, subsection 1, clause 11. Now, this provision says, my lord, that Section 3. Yes, it will be better if your lordship takes up, my lord, this provision. My lord, in this book, if your lordship is
2017 Act.
yes, my lord, if your lordship is carrying this book,
Oh.
the 17 Act, my lord, starts from page 99.
Yes.
And the relevant part of Section 3, my lord, subsection 1, clause 11, is that page, my lord, 111, my lord.
Yes.
It reads as follows. In case of venture primary school, this will include, my lord, AMI school also, my lord. Because the definition of AMI school or venture school, it will include AMI school also. There shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics, B, social studies, and C, languages. Provided that for additional post, it shall be considered in accordance with the norms and standards stipulated in the schedule under Section 19 and 25 of the Right to Education, Children to Free and Compulsory Education Act 2019. Now, your lordship has seen that it mandates, my lord, that one teacher from each subject, science and mathematics, social studies, and languages. And if your lordship sees the language of this particular mandate, my lord, the expression shall, my lord, is, my lord, incorporated. There shall be minimum 3 teachers. And in case, my lord, they want to appoint additional or provincialize additional, my lord, post, that will be guided by Section 19 and 25 in relation to teacher, my lord, student ratio. Now, here what has happened, my lord, this particular mandate, my lord, has been diluted. Because instead of, my lord, taking 1 teacher from each subject, what they have done, I'll show from the, my lord, appointment letters, they have appointed 2 teachers, my lord, from science.
Okay.
And 1 from social studies. Thereby, they have excluded, my lord, language. So therefore, my lord, essentially, the respondents have diluted the mandate of this, my lord, particular provision. So therefore, my lord, I am challenging that this particular dilution could not have taken place. Number 1. Number 2, in terms of, my lord, this provision, now it is incumbent on their part to consider my case as I belong to language. Number 1. And number 2, my lord, I'll show, my lord, from records that there is an interim order operating in my favor in the writ petition of 2012, which is before your lordship. There is another case of 2012 in this particular series, my lord. That interim order is still operating in my favor, saying that without consideration my case for provincialization, the others, my lord, may not be considered. Now, that interim order, despite being alive till date, my lord, they have not, my lord, complied with. My lord. So on these 2 counts, I am praying before this honorable court that my case for, my lord, consideration in respect of provincialization by the respondents may be done by the district level scrutiny committee and the, my lord, state level committee. My lord, more or less precisely, my lord, this is the case. Now, if your lordship comes to, firstly, my lord, the order, interim order.
In the second case.
Now, in the first case itself, I have annexed everything. This case, my lord, which your lordship is taking up.
4998.
Yes, my lord, 4998. Each and every document is annexed here with my lord. Your lordship will come to page 36, annexure 7.
Yes.
Now at the top, your lordship will see WBC 4773/12. This is the writ petition which is pending and has, my lord, is listed before your lordship. And my lord, there was a miss case 195/13. In this miss case, my lord, this order has been passed, dated 14/5/2013. Now I'm reading out the order. My lord, it's a short order. The petitioner claims to be senior. Petitioner, your lordship will see Sonabuddin Molla, the present petitioner. Petitioner claims to be senior to the private respondent 7 and 8, namely Sheikh Mohammad Zakir Hussain and Sheikh Anwar Hussain, respectively, in the Bahadur Tari Army School. The inter se seniority issue was decided by the Director, Elementary Education Assam. So his order dated 21/6/12. Lordship will take note of this order. I'll come in next, my lord, to this order. 21/6/12, whereby the petitioner was declared to be senior to the two respondents. Both the respondents, I was declared to be senior. Mr. B.C. Chaudhary, the learned counsel appearing for the private respondents, however, contends that the petitioner was appointed as an additional teacher and is therefore disentitled to provincialization, since only assistant teachers are entitled to the benefits under the Assam Venture Education Institution Provincialization Act 2011. Be that as it may, having regard to the interim order of 9/11/12 in WPC 4773/12 and the seniority declaration in petitioner's favor made on 21/6/12 by the DEE Assam, the services of the respondents 7 and 8 should not be provincialized in the Bahadur Tari ME School by ignoring the petitioner. Now, though, my lord, this order was passed in the earlier Act of 2011. Now, that act has been, my lord, superseded by the present Act. But nonetheless, my lord, this writ petition, my lord, is pending till date. And by invoking the doctrine of least pendants, my lord, since this is pending, my lord, this particular interim order does not, my lord, become redundant or otious, my lord. This is my first respectful submission. Now, this particular order, my lord, has not been taken into consideration by the district level scrutiny committee while, my lord, preparing the, my lord, recommendations, my lord. I'll come to the, my lord, district scrutiny committee, my lord. Before that, your lordship will come to page 32, annexure 5. This is the, my lord, order of the director, which finds reference in the interim order, which I have drawn your lordship's attention. Now, this order, your lordship will see, is passed by the Director of Elementary Education. And at the top, my lord, your lordship will see the reference of the order. The order and direction of the Honorable High Court passed in 10/2/12 on WBC 633/12. Sonabuddin Molla versus State of Assam and others. So this order is essentially passed, my lord, pursuant to a High Court's direction. Now, the operative part, if your lordship comes to down below, decision, it appears that the petitioner is senior, that the respondent in service, as per records, the joining of the petitioner respondent is as follows. Mohammad Sonabuddin Molla, date of joining 8/8/95. Now, this order is drawn your lordship's attention only to, my lord, substantiate the fact that my joining has been ascertained by the director pursuant to a, my lord, direction of this honorable court as 8/8/95. So any consideration in respect of provincialization, so far as the petitioner, my lord, is concerned, shall be governed by this order, my lord, of the Director of Elementary Education. And this order is presently holding the field, my lord. Subsequently, what has happened, my lord? The district level scrutiny committee at page 46, my lord, has sent the recommendations. Annexure 11, page 46. Now, your lordship will come to next page, 47. Column 6, my lord, name of the teachers. These are the teachers whose names were recommended. Naushad Ali Sarkar, Abdul Jabbar Majumdar, Sheikh Mohammad Zakir Hussain, Anwar Hussain Sheikh. Now, these are the persons, my lord, whose name was recommended. And if your lordship comes to column 7, my lord, my name figures Sonabuddin Molla, assistant teacher language. Now, the reason which is cited for not sending my name is in column 7, details of teacher tutor who are not eligible for provincialization due to non-availability of required enrollment. So therefore, on the garb of, my lord, the lack of the teacher-student ratio, my lord, name has not been forwarded. Sonabuddin Molla, assistant teacher language.
Yes.
Now your lordship will find what has happened thereafter. pursuant to the recommendation of the District Scrutiny Committee, I take your lordships, my lord, 2 appointment letters, which reflects, my lord, the present state of affairs. At page 49, the first appointment letter. This is a type copy, and my lord, the original letter is at page 50. I take your lordships to the type copy, page 49. This is an order of 5th February 2021. Now, your lordship will see the name of Naushad Ali Sarkar, whose name appears, my lord, in the district level scrutiny committee report. I read it out, my lord. In pursuance of the government order number so-and-so, and in accordance with the provisions contained in Assam Education Provincialization of Service of Teachers Reorganization Education Institution 2017, Governor of Assam is pleased to provincialize the service of the following person of recognized UPS as tutor science with effect from 1st January 21. This is an appointment letter appointing, my lord, Naushad Ali Sarkar against science stream, my lord. Now your lordship will come to the next, my lord, determination by the secretary pursuant to a high court's direction, which starts at page 56, my lord. In the meantime, what happened? One of the aggrieved party, my lord, that is Mohammad Zakir Hussain, he filed a writ petition before this honorable court, and the honorable court directed the secretary to, my lord, dispose of the appeal filed by him pending before the government. And resultantly, my lord, at page 56, the secretary had passed this order. Now, this is an order of 31/7/24, my lord. The reference of High Court's order is mentioned at the top. Honorable High Court order dated 10/4/23 in WBC 3452/21. Now, if your lordship comes to the next page, first page may not be, my lord, necessary or relevant. Next page, page 57. Records reveal that DEEO Dhubri had recommended 2 science teachers against Bahadutari Army School for provincialization of services, namely Abdul Jabbar Majumdar, who joined on 81/93, and Anwar Hussain Sheikh, who joined much later on 5/2/2008.
1 minute. Okay.
Now, this, my lord, Abdul Jabbar Majumdar, my lord, this respondent 7, sorry, my lord, respondent 8.
Presently.
Presently, my lord. Abdul Jabbar Majumdar joined on 18/1/93, and Anwar Hussain Sheikh, who joined much later on 5/2/2008. Record reveals that SLC in their minutes dated 3/5/23 had recommended cancellation of provincialization of service of Anwar Hussain Sheikh as science and maths tutor of Bahadutari Army School, and recommend for provincialization of service of petitioner Sheikh Mohammad Zakir Hussain as social science tutor of Bahadutari Army School. Now, this is the order of the relevant part. Order. In view of the above facts and circumstances, as the name of the petitioner, Sheikh Mohammad Zakir Hussain, was recommended for provincialization of service as social tutor, science tutor of Bahadutari Army School by both the DLC Dhubri as well as SLC DEs to take needful steps in this regard. So therefore, Sheikh Mohammad Zakir Hussain, my lord, he is recommended, or it is, my lord, he is directed to be provincialized against social studies. As only one science and maths tutor can be provincialized, the provincialization of service of Anwar Hussain Sheikh as science and maths tutor of Bahadutari Army School is hereby cancelled. So initially, my lord, Anwar Hussain Sheikh was appointed. By this order, his appointment has been cancelled, and thereby, my lord, the other 2 in respect of science and social studies, my lord, has been, my lord, recommended for appointment.
Other 2 means
respondent 7 and 8, my lord. Mohammad Sheikh, Mohammad Zakir Hussain, and Abdul Jabbar Majumdar.
Okay. Abdul Jabbar Majumdar is
Science, my lord.
science.
And my learned friend's client, social studies, no?
Yes.
His social studies, my lord. So far as social studies is concerned, my lord, there is no difficulty, because this is for the, my lord, first teacher in social study. So far as science is concerned, already 1, my lord, has been appointed.
That Anwar Hussain.
Anwar Hussain, my lord. No, my lord, that I have already drawn your lordship's attention. Naushad Ali at page 49.
Oh. Yes, Naushad Ali.
Yes, my lord, what appears from the District Scrutiny Committee report, Naushad Ali, my lord, his name was recommended in a language at page 47.
Oh.
But the appointment was, my lord, in respect of science, my lord. Now, whether it was a mistake, whether it was deliberate, The respondents cannot, my lord, now, my lord, take a, my lord, ground, my lord, that his name was recommended against language. So therefore, it has to be considered that his appointment is against language. Such an argument, my lord, will hold no water at all. Because this order, appointment order, my lord, was not cancelled at any point of time. And by this time, in November 22, this person has retired, my lord. And this is an order in the name of the governor. So therefore, even if, assuming, my lord, that there is a mistake on their part,
He
in appointing,
retired in
my lord,
November 2022.
yes, November 22, I have made a statement, my lord, already retired. So therefore, by this time, there is no opportunity even to rectify a mistake. What has been done is done, my lord. So apparently, my lord, from the materials on record, as on date, there is no consideration in respect of the, my lord, stream of language. And having regard to the mandate of, my lord, 3(1) clause 11, my lord, this is a mandatory provision, my lord. It's not a directory provision. So therefore, there is no scope or chance, my lord, to dilute the same. The respondents cannot take a ground that since the quota is filled up, 3 teachers has been already been appointed. So therefore, now you cannot enter into the area. Such an argument, in my respectful submission, my lord, is not permissible.
See, this Talukdar,
My lord,
this Naushad Ali Sarkar,
my lord,
initially he was appointed as a science teacher,
My lord.
science tutor,
yes,
retired in 2022.
22, my lord,
Then the second order
yes,
of the secretary,
my lord.
with Sheikh Muhammad Zakir Hussain.
Yes, my lord, that will, my lord, reflect from page 56 itself. If your lordship comes to page 56, the preceding page, the last part of the order, record reveal that DSC Dhuri had recommended the name of the petitioner, Sheikh Muhammad Zakir Hussain, for provincialization of service as social science tutor. Muhammad Zakir Hussain, my lord, is social science tutor.
Okay.
And Abdul Jabbar Mujumdar, my lord, he is science. So therefore, by this order, again another science teacher has been appointed. My lord, essentially my respectful submission is, I am, my lord, not to disturb the appointment which had been made by this order. Though this order is impugned in the present case, my lord, only as a technical ground. Otherwise, they will come up with the plea that this order is not under challenge. I have challenged this, my lord, but I don't intend, my lord, to disturb their, my lord, provincialization, which have already been done. What I am on, that there is already an interim order operating, my lord, in my favor. By invoking the doctrine of least pendants, this interim order has not become redundant, number one. Number two, the mandate of 3(1)(11) is, my lord, a mandatory provision. There cannot be any dilution in respect of the same. So, being an administrative authority, you are bound by the mandate of law.
So till date,
My lord,
my lord, no language teacher has
no language teacher. Apparently from the materials on record, no language teacher. So my humble submission is, my lord, it will be proper on the part of the respondents, my lord, because that will amount to comply with the mandate of law also, my lord, and comply with the interim directions of this honorable court also. Let them consider, my lord, because I am now the only language teacher, and your lordship will appreciate the director has held. I have, my lord, I have been rendering since 1998. After 2-3 years, my lord, I will complete 30 years. Lordship will see my lord, pathetic condition. I am rendering, my lord, without any remuneration, nothing. At the fag end of my career, if I am provincialized, at least some solace, my lord. And in fact, from the, my lord, on the ground of, my lord, the mandate, from the perspective of mandate, my lord, they are bound to comply with, my lord, section 3(1)(11). Until that, my lord, there is non-compliance of the same. So this is my humble submission, my lord. I don't intend, my lord, to disturb the appointment of the my learned client, my lord, friend's client, neither the respondent 7 nor the 8.
1 minute. Who are the 7 and 8?
Sheikh Muhammad Zakir Hussain, my lord, Abdul Jabbar Mujumdar, whose provincialization has been done by the order of the secretary, my lord. 31/7/24. I'm making an inauspicious prayer, my lord. Perhaps my learned friend will agree. Anwar Hussain, no, Hussain. ঠিক আছে এইটো হৈ যাব এপইণ্টমেণ্ট লেটাৰ পাই যাবা
Sheikh Mohammed Zakir Hussain is a social science,
my lord
correct?
yes
Respond to 7,
yes
social science.
social science teacher because it reflects in page 57 also my lord.
Oh.
Record reveal that DO Dhubri had recommended two science teachers against Bahadur Tari Army School, provincial of service, namely Abdul Jabbar Mujumdar and Anwar Hussain Sheikh. These are science teachers, my lord. And order in the order part, your lordship will see, in view of above facts and circumstances, name of the petitioner, Sheikh Mohammed Zakir Hussain, was recommended for provincial of social science tutor. So Sheikh Mohammed Zakir Hussain, social science. This is the respondent, my lord, 8 or 7, my lord. And respondent 7 is Abdul Jabbar. Respondent 8 is Abdul Jabbar, who is against pilot science.
No, by this order, this Abdul Jabbar is not appointed.
Abdul Jabbar is appointed being the senior, my lord. Because your lordship will see the last part, only one science and maths tutor can be provincialized. Provincialization of Anwar Sheikh as science and maths tutor is hereby cancelled.
Okay.
So Anwar Sheikh cancelled.
Abdul Jabbar.
Jabbar comes in, and my lord, my learned friend's client comes in, my lord, respondent 7, Zakir Hussain.
Oh. Okay.
My lord, this is my respectful submission, and only one observation, my lord, is necessary. Your lordship had, my lord, allowed a review application filed by the petitioner. That is at page 42, my lord. If your lordship comes to page 42, this is the order of review, and page 43 is the order dated 22/8/23. Now, the last part of the order at page 45, your lordship will come to para 5, my lord. In that view of the matter, the order dated 28/5/14 passed in WPC 4773/12, the other matter which is pending, my lord, is hereby cancelled. Review petition is accordingly allowed. WPC 4773/12 is restored back to file. Now, my lord, this particular order, 28/5/2014 of the Honorable Court is recalled. Now, once, my lord, it is recalled, the consequential order, which was passed pursuant to this High Court's order, it also, my lord, loses the legs to stand. Now, that consequential order, your lordship will find at page 40, my lord. 40. Annexure 9. Your lordship will see at the top of the order, peruse the Honorable High Court's order dated 28/5/14. This is the order which your lordship has recalled, passed in WPC 4773/12. Now, this is the consequential order which was passed pursuant to the High Court's direction and which your lordship had recalled in the review application. So essentially, my lord, your lordship will make an observation. If my case of considering, my lord, provincialization is considered, I will be governed by the order of the director, which is, my lord, at page, my lord, 32, which I have drawn your lordship's attention. And this order, which is to my prejudice, will have no bearing, man. Page 32 order of the director, my lord, which was also passed pursuant to the High Court's direction, man. Which, my lord, wherein, my lord, my appointment has been shown as 8/8/95. So this is my lord, humble submission, but my learned friend says.
Here, my lord, posts are personnel. My lord. Once, my lord, person is appointed, his retirement post will go.
Okay, that's fine. That was science.
That is language, my lord. Person.
No. How can you say it's
No, my lord, person who is appointed as a language teacher.
Where?
He has already retired.
But he was not appointed as a language teacher.
Who is the language teacher?
Yes, he was not appointed.
Kindly see, my lord.
Page 50.
Page 47, recommendation of the district scrutiny committee.
Okay, fine. That is fine. That I've seen.
Nausad Ali Sarkar, my lord, he was recommended as
Language teacher. What does your order say?
My lord, here, my lord. Recommended, recognize UPSC tutor science with effect from here, my lord. As per the order, it is, my lord.
So even if the district scrutiny committee has recommended that Naushad Ali
My lord,
as a language teacher,
my lord,
when the order came out,
my lord.
he was provincialized as
As
a
a
science tutor.
tutor, my lord.
So practically, there was no consideration of any language teachers.
My lord. If that be so, my lordship may remand back.
No, it is not. If that be so, you have to be very clear.
My lord.
Let us be very clear before we pass an order.
True, my lord, that is there, my lord. As per the order, my lord. As per the order, this Nosad Ali Sarkar was recommended as, my lord, tutor science, my lord. And, my lord, but the DLC has recommended his name as a language teacher. Now, my lord, this Nosad Ali Sarkar is already retired, my lord.
Retired as a science tutor.
My lord. Language, post of language teacher is now still vacant. Lordship may direct the district scrutiny committee to recommend the name of the petitioner as per the law. Existing law.
I am for the respondent number 7, Sheikh Mohammed Zakir Hussain. As per the, it is apparent in the records that it is apparent from the record that appointment order has not been issued to the Sheikh Zakir Hussain, although the district level escort technical and as well as the state level escort technical recommended. He has to be appointed it. Also, my lord, the subsequential process of appointment of the Sheikh Mohammed Zakir Hussain shall not be disturbed. That is my humble submission.
Cannot be disturbed. I'm not coming in his way. His social studies.
Yes, my lord.
He should not be anxious. I have made it clear, my lord.
I am social studies subject is linguistic.
Absolutely.
Linguistic. So his consideration cannot be disturbed my consequential process of provincialization.
And what are in the other two cases?
Other two cases, my lord, in fact, that is in the other case, essentially, my lord, that 24 case, I had, in fact, challenged the consequential order pursuant to the review. Your lordship can pass the order here also, and this, my lord, particular order will, my lord, cover the other two cases also. And 2012, that relates to, my lord, certain benefits arising out of my seniority in terms of the director's order. So this order will cover the entire, my lord, three cases.
Yes, Bora.
Let me remand back to the district scrutiny committee to recommend.
No, are you sure about it? You've got only your instructions.
My lord, actually, my instruction is that his name has not been recommended by the district scrutiny.
Oh, that is correct.
Absolutely correct.
Are you ready for disposal? Otherwise,
I have no objection if lordship remand back the matter to the district scrutiny committee to recommend his name as per the law. Existing law, my lord, not as per the 2011.
okay. You must be ordered WC 4998 of 2020. Okay. Heard Mr. S.K. Talukdar, learned counsel for the petitioner. In all the three writ petitions, is it?
My lord, three petitions.
In all the three writ petitions. As well as Mr. P.K. Bora, learned standing counsel, elementary education for the respondents. 1, 2,
1, 2,
4, 5, and
4,
6.
5, and 6, ma'am.
4, 5, and 6.
My lord.
6. Mr. B. Deori, learned government advocate for the respond number 3. And Mr.
R. Islam.
R. Islam,
For
learned
respondent
counsel
number 7.
for the
Respondent number 7.
only 7.
Only 7.
Respond number 7. 8 is not represented.
No, madam. He's making the rest.
Stop. Para. Para. Pursuant to a resolution of the managing committee of the Bahadur Tari ME School, Goba, comma, to free. The secretary, comma, management committee of the said school by an order dated
8895, ma'am.
8/8/1995 appointed the petitioner as
As assistant teacher, ma'am.
section teacher, is it?
Yes. Section teacher.
As section teacher of the said school.
Your lordship will see page 22. The resolution, my lord, says as assistant teacher. Sonabuddin Molla, assistant teacher. This is a resolution of the managing committee.
But in the order says section.
Yes. My lord, order is passed pursuant to the resolution, my lord. Anyway, my lord.
Section teacher of the said school. Now, the petitioner accordingly joined on 8/8/1995. Stop. In the meantime, by an order dated what date is this? Annexure 3,
Annexure 3, my lord.
16/12/2005,
Yes, ma'am.
issued by the Director, Elementary Education Assam. The Bahadur Dari ME school, along with 4 other schools, were given temporary recognition with effect from 1/1/2005. Stop. This financial assistance is, do we need to go into this?
Here, my lord, now not necessary because at that point of time, he had to approach the court because he was shown to be junior and depriving my lord the financial assistance. Now this is not relevant, my financial assistance part.
No, but then this order, I have to refer to this order, isn't it? Page 32.
My lord,
Page 32.
page 22,
32.
32.
Oh. 21/6/2012 order.
Yes, page 32 was passed pursuant to the order at page 30, my lord. Page 30 is an order of the Honorable High Court.
The petitioner, Farhan, approached this court by filing WBC number 633/2012. Inasmuch as he was not granted the financial assistance. Stop. He was not paid the financial assistance in terms of the order dated
Look, in terms of the prevailing policy, my lord.
cancel it. Whole line, huh? Whole paragraph. The government of Assam, comma, took a policy decision to provide financial assistance to the venture schools oblique madrasa on the basis matters stop. Whereby such financial assistance is given to the headmaster
Yes.
and other assistant teachers of the schools. Stop. However, comma, as the petitioner was deprived of giving the financial assistance, comma, the petitioner approached this court by filing WBC number 633 oblique 2012, which was disposed of by an order dated 10 to 2012, directing the director of elementary education to cause an inquiry and directing to cause an inquiry and then to decide the issue relating to seniority of the petitioner vis-a-vis two other respondents, two other private respondents for the purpose of financial assistance. Stop. Para. Consequent thereto, comma, the Director Elementary Education Assam, after hearing the parties, passed an order on 21st of June 2012, wherein whereby the petitioner was declared to be senior and his date of joining was indicated as 8/8/1995. Stop. Para. Then what is this other writ petition 4773?
Yes, my lord, this is presently pending. Again, he approached, my lord, despite the determination by the director, my lord, he was shown to be junior. So being aggrieved, my lord, he filed this writ petition because by that time provincialization came in, my lord. 4773/12. And here, my lord, the interim order was passed regarding provincialization at page 36, my lord.
Para. Despite the order passed by the Director Elementary Education Assam, dated 21st June 2012, comma, the petitioner was shown to be junior amongst the list of teachers of the Bahadur Tari ME School in Dhupri district. Stop. Continue to be shown as junior. Huh? Stop. He therefore again approached this court by filing WBC number 4773/2012. Stop. This court on 9/11/2012 passed an interim order directing that the share of financial assistance issued to the Bahadur Tari MA School in Dhubri district shall not be dispersed either to the private respondents or to the petitioner in the said petition, and your share shall be kept aside. Stop. Further, comma, the petitioner preferred another miscellaneous application, being MC 195/2013, wherein this court, by order dated 14/5/2013, directed that in view of the seniority declaration in favor of the petitioner by the order dated 21/6/2012, issued by the Director of Elementary Education Assam, the services of the respondents 7 and 8 therein, namely Sheikh Muhammad Zakir Hussain and Sheikh Anwar Hussain, correct,
Correct, Malord, correct.
should not be provincialized in the Bahadur Dari MS School by ignoring the petitioner. Stop.
As per
At least-
2011 Act, madam.
Huh?
As per 2011.
Under the Assam Venture Educational Institution, within bracket Provincialization of Services Act 2011. Stop. Sapara. It is to be noted at this stage that the interim order dated 9/11/2012, passed in WBC 4773/2012, and the order dated 14/5/2013, passed in MC 195/2013, is still subsisting till date. Correct?
Correct, Malord.
Both.
Yes, both, Malord.
Stop. Para. You again approach this court.
No, no, Malord. In fact, what happened? Your Lordship had found that this order at page 38, which is operative part page 39, this suffers, my Lord, from error apparent on the face of the record.
No. For what reason did you come to court?
My Lord, 4773, 4773, which your Lordship has already indicated, that I was shown, my Lord, below. My placement was below, despite there being an order of the director. So I
Okay.
approached this court, my Lord.
Okay. In the meantime, by an order dated, then that other interim order is not in subsistence.
No, this has been, my Lord, now restored, because this is restored, my Lord.
In the meantime, WBC number 4773/2012 was disposed of by an order dated 28/5/2014, directing the respondents, more particularly the Director of Elementary Education Assam, to course a scrutiny of the matter through the prescribed agencies to determine as to who is senior, comma, the petitioner or the respondent number 7 therein, I, Sheikh Muhammad Zakir Hussain. Stop. Para. Pursuant to the order dated 28/5/2014, passed by this court in WBC number 4773/2012, the it is a member secretary.
My Lord.
Member secretary.
Yes, my Lord, he is subordinate to the my Lord, member secretary, district elementary education officer. He is subordinate to the director. This is the consequential order passed, my lord, page
The
14.
Member Secretary, comma, DSC, District Elementary Education Officer Dupri, passed an order on what is this? 11/8,
My lord, yes, 11/8,
11/8,
2014.
2014. Whereby
I was shown to be appointed on 24/11/2007. Findings, my lord, facts and findings. Third paragraph.
whereby the petitioner was shown to have been appointed on 24/11/2007, and the claim of the petitioner as assistant teacher was rejected. Stop. Para. The petitioner again filed a review petition, being review petition number 65 of 2017, praying for review of the order dated 28/5/2014, passed in WC number 4773 of 2012. Stop. This court, after hearing the parties, disposed of the said review petition by order dated 22/8/2023. By coming to the conclusion that the order dated
28/5/14. Page 45.
came to the conclusion that there was an error apparent on the face of record while passing the order dated 28/5/2014, passed in WBC 4773 of 2012, inasmuch as the order dated 21st of June 2012, issued by the Director of Elementary Education Assam, was overlooked. Correct?
My lord, correct. Absolutely.
Accordingly, the order dated 28/5/2014, passed in WBC 4773 of 2012, was recalled. And WBC number 4773 of 2012 was restored back to file. Stop. Para. The government of Assam enacted the Assam education within bracket provincialization of service of teachers and reorganization of educational institutions within close bracket Act of 2017, wherein at clause 3 within
Section 3.
bracket wherein at section 3
Clause, subsection 1, clause 11.
within bracket 1 within bracket 11 provides that in case of venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for within bracket A, science and mathematics, within bracket B, social studies, and within bracket C, languages. The proviso indicates, not proviso is
Not necessary.
Stop. Para. On top, you say Act of 2017 in short. No? In terms of the provision but of the Act of 2017, the process for provincialization of the services of the teaching and non-teaching staffs of the Bahadur Tari ME School started, and the District Scrutiny Committee Dhupri made a recommended the case of one Naushid Ali Sarkar for provincialization as a language teacher. Stop. Further, the respondent number 7 and for this and the respondent number 8. Further, the case of the respondent number 7 and the respondent number 8 were also recommended for provincialization as social studies and science and maths. No, also recommended for provincial as tutors in social studies and science and maths respectively. Stop. However, the case of the petitioner was not recommended on the ground that there was on the ground of non-availability of required enrollments. Stop. Consequent thereto, the Director Elementary Education Assam provincialize the case of one Naushad Ali Sarkar as a tutor in science with effect from 1st January 2021 by an order dated 5th February 2021. Stop. The petitioner being aggrieved for non-consideration of his case for the post of for non-consideration of his case as a tutor in the as a tutor within bracket language has approached this court by way of the present petition. Stop. Para. Mr. S.K. Talukdar, learned counsel for the petitioner, submits that when section 3 within bracket 1 within bracket Roman 11 provides that 3 teachers, namely science and maths, one in 3 teachers each in science and maths, social studies and languages have to be considered for provincialization of the services, the District Scrutiny Committee did not consider the case of the petitioner as mandated by section 6, section 3 within bracket 1 within bracket Roman 11. Stop. He also submits that in terms of the directions passed by this court in WBC number
Page 51, man.
no one
345.
in WBC number 633
Man, 6.
oblique 2012. comma, the Director, Elementary Education has passed an order on 21/6/2012, whereby the petitioner is shown senior to the respondent number 7, correct?
My lord.
And his date of joining is indicated as 8/8/1995, whereas that of the respondent number 7 is shown as 12/2/2008. Stop. Where was it order?
Order of the government at page 56, my lord, pursuant to the High Court's direction at page 51.
Further comma, it is submitted that pursuant to a direction passed by this court, pursuant to a direction passed by this court in WBC number 3452/2021, within bracket, you say Sheikh Muhammad Zakir Hussain versus State of Assam and others. Pursuant to an order dated 10/4/2023, passed by this court in Delhi. The Secretary to the Government of Assam, Department of School Education, passed an order on 31/7/2024, whereby
Respondent 7 against social studies, my lord, and 8 against science.
whereby the respondent number 7 was recommended for provincialization of service as a social science tutor, and the respondent number 8 against
Science and mathematics, my lord.
against science and mathematics. Stop. He therefore submits that at no point of time the respondents have considered the post of has considered the post held by the petitioner, within bracket language, for provincialization as mandated under section 3 within bracket 1 within bracket Roman 11 of the Act of 2017. Stop. Therefore, comma, therefore he submits that the matter be that the respondents be directed to consider the case of the petitioner for provincialization of his service as a tutor in the language subject. Stop.
In terms of the act as well as the interim order, my lord.
In terms of section 3 within bracket 1 within bracket Roman 11 of the Act of 2017, as well as the interim order passed by this court
Page 36, my lord.
on
14/5/13.
on 14/5/2013 in MC number 195/2013 in connection with WBC number 4773 of 2000. Stop. Mr. B.K. Bora, learned, Standing Council Elementary Education Department, submits that the district level committee has recommended the case of the where is that scrutiny committee recommendation?
Page 46, my lord.
Has recommended the case of one Naushad Ali Sarkar against the language subject. Stop. He therefore submits that the district scrutiny committee has taken steps in terms of the requirements met under section 3 within bracket 1 within bracket Roman 11 of the Act of 2017. Stop. Further submission is made that the provincialization of services of the teachers are what will you say?
Personal matter.
Are personal to those teachers. And once the teacher incumbents retires, oblique retires, the expires, the set vacancy the set vacancy
Extinguished.
stands extinguished. Stop. He also submits that the said Naushad Ali Sarkar has already retired in the month of November 2022. And therefore,
That information that
As
stated by the.
okay, then I cancel that. Stop.
Your lordship may record my submission.
Mr.
R Islam.
R. Islam, learned counsel for the petitioner. Learned counsel for the respondent number 7
Seven, Sheikh Mohammed Zakir.
submits that in terms of the order, or the secretary's order,
My lord, page 56, my lord. 30.
in terms of the order dated 31/7/2024, the issued by the Secretary, Governor of Assam, Department of School Education, the respondent number 7 has been recommended for provincialization as a social science tutor, and therefore, as the petitioner is seeking for provincialization only as a language teacher, the process of provincialization of the service of the respondent number 7 should not be disturbed. Stop. Para. After hearing the learned counsel for the parties. No, this court has considered the submissions made by the learned counsel for the parties. Stop. Para. Section 3, within bracket 1, within bracket Roman 9 of the Act of 2017.
Roman 11, my lord.
11. This is under. 8 way. You quote this. Stop. Para. This court, by an order dated 14/5/2013, passed in miscellaneous case number 195 of 2013, directed the respondents not to provincialize the services of two teachers, namely Sheikh Muhammad Zakir Hussain and Sheikh Anwar Hussain, without considering the case of the petition. The relevant portion, which is under page 37, PDP. Stop. It is to be noted that the order dated 14/5/2013, passed in MC 195 of 2013, is still in subsistence till date. Stop. Para. The District Scrutiny Committee, (DSCC), while making its recommendation for provincialization of the services of the teachers of the Bahadur Dari MS School, recommended the case of one Naushat Ali Sarkar as a language teacher. Stop. However, when the provincialization order of the said Naushat Ali Sarkar was issued by the order dated 5th February 2021, the said Naushat Ali Sarkar was provincialized as a tutor within bracket science. Stop. It is the submission of the Learned Council for the petition that the said Naushat Ali Sarkar has retired in the month of November 2020. Stop. Be that as it may, what is to be noted is that despite the District Scrutiny Committee recommending the case of the petitioner of the said Naushat Ali Sarkar as a language teacher, his provincialization was done as a tutor in science. Stop. This would indicate that at no point of time the case of the petitioner was considered for provincialization under as a language teacher. Stop. Further, the director of elementary education, the director elementary education department, by an order dated 21st June 2012, has already declared the petitioner to be senior than the respondent number 7. And the date of joining of the petitioner is indicated as 8/8/1995. Stop. Under the circumstances, this court is of the considered opinion that the petitioner has been victimized inasmuch as he has not the petitioner's case was never considered for provincialization as a language teacher as required under section 3 within bracket 1 within bracket Roman 11 of the Act of 2017. Stop. Accordingly, without expressing any further opinion on the merits of the case, the matter is remanded back to the District Scrutiny Committee.
Instead of saying remanded back, because my submission is at no point of time the provisions of the Act has been complied with. Now it is
Accordingly,
incumbent on their part to comply with the provisions of the Act.
the
Lordship will record this submission.
the respondents are directed to consider the case of the petitioner for provincialization as a language teacher oblique tutor in terms of section 3 within bracket 1 within bracket Roman 11 of the Act of 2017 by following the due process of law.
Malot will make it clear because this particular mandate was not followed because till date language has been excluded, Malot.
That I've already
Yes,
said.
yes, correct, man.
Let such exercise be done and completed within a period of
3 months. But
okay 3 months.
only thing is that I want to submit he is not victimized. He is a language teacher, and other thing
He has been victimized.
One other thing is that Naushad Ali Sarkar is senior to him,
Maybe, but he was provincialized as a science teacher. Whatever the DSC must have done, that is a different thing. But the final order is that he was a science teacher. Therefore, the petitioner was never considered. That will you have victimized him.
Yes.
Stop. This court also makes it clear that it is also made clear that this court is also not interfering with the process of provincialization
Yes.
of the respondent number 7 in terms of the order dated
31/7/24, my lord.
31/7/2024 passed by the Secretary to the Government of Assam, Department of School Education.
Yes.
With the aforesaid observations and directions, all this will be
My lord, the process shall be completed from today. My lord, Lordship will fix the date.
from the date of receipt of this.
Certified copy of this order.
Yeah.
My lord, I will submit before the, my lord.
That is up to you.
No, Lordship will, my lord, District Scrutiny Committee is headed by the Deputy Commissioner. So Lordship will specify it. Otherwise, nobody will accept my lord certified copy.
Okay. From the date of receipt of a certified copy of the order of this court. The
District Commissioner, my lord. South Salman,
the petitioner,
Dhubri.
the petitioner is also permitted to furnish a certified true copy of this order to the
Deputy Commissioner,
to
my
the
lord.
Deputy Commissioner Dhubri
My lord,
for doing the needful.
deeply obliged. I'm deeply obliged.
Up to that only, it is made clear. Huh?
Item 20.
My lord, may it please your lordship, my lord, this is a case of a medical admission. Your lordship may look into the last order dated 4/11/24. My friend has got an instruction today and request has asked to inform the client to go for an admission today. Because I obtained a more marks, my lord. 563. नहीं कोई लोग मेरे साथ देखा तो बोले ये पूरा स्कीम তুমি কই দিলে হল তুমি কই দিলে হল বিশেষ দিলে কইছো সাবজেক্ট অফ করতে কইছিলে না না তুমি না ভ্যাকেন্সি পালে আমি পাই যাব সেইটো এটা ইন কেস যদি ভ্যাকেন্সি হয় আমরা এনি ক্যাটাগরিরও লিখলে মানে আমি এটু ক্যাটাগরি না থাকবো পারে In the next page only, my lord, the petitioner has secured, it is not 536, it's 563.
No, it is 563. It is 50.
Yes. It is 50.
He said, it's open.
What is GI quota?
Government
Mobile
institution.
is that 5 under unreserved category.
Oh, the level of conscience of the pay. Variation pay. Either put out the other. It only like don't have any data. Only thing, my lord, I can because he has.
What instructions I have got is this, my lord. Yesterday, my lord, online counseling is over for BDS. But my lord, as per my lord past experience, usually my lord seat remains vacant under my lord BDS. Now, my lord, because of not receiving the my lord report from the secondary education regarding his my lord schooling for class 11 and 12, he could not be considered under GI. So we have admitted in the one sentence that otherwise he would have got under my lord under the BDS code. So what the DMES today my lord informed, in fact it is there also. If I have in fact informed the petitioner side also that if he comes to the DME's office today, because all admission will be taken up there, if any vacancy is available till the evening, my lord, he will be immediately accommodated.
Then why not you approach the
He
DA?
is
No,
already
no, I have
informed.
informed, they are coming to the DMA
Yes.
office.
Along with all his particulars,
He
and
is
that
always-
admission will be subject to outcome of the report from the secondary education regarding his class 11 and 12 status of
We
his
have,
school.
we have already informed, but he is on his way.
That must, if your lordship indicate, he will be accommodated if any vacancy is available under any category, that lordship may indicate.
In any category, my lord?
No, 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 I didn't get you.
First, by today evening, under any category in BDS, my lord, if any seat is available, then my lord, lordship will direct that he should be accommodated in such a vacancy. Subject to the outcome of inquiry of his, my lord, certificate, school certificate of class 11 and 12.
By the
Class
authority.
7 to 9, 10 we have got, my lord. It is a government institution. There is a procedure, my lord. For 11, 12, it is awaited. For that reason, he could not be considered at that point of time when the third round of counseling was held. So he got left out. And he also, my lord, he did not approach the honorable court in time. Even then, my lord, the DMES stated that let him approach the office today. Counseling is going on, my lord. If any vacancies remains by the evening, my lord, he will be accommodated immediately.
And I am bringing all my credentials, my lord. I will.
Only that, my lord, subject to outcome, my lord, of the inquiry
We
of
will
the
keep this writ petition pending.
Pending.
Lordship may keep it, my lord. Lordship may
But
proceed
Mr.
tomorrow also,
P.K.
my lord,
Roy
we will
Chaudhary,
have
learned
this.
counsel for the petition. Mr. B. Gogoi, learned standing counsel Health Department, submits that the case of the petitioner could not be considered.
First of all, when the case of the my lord, so where the rank is of the petitioner is concerned, he is otherwise not entitled on merit for the for a seat under my lord for MBBS seat under my lord UG, my lord unreserved my lord GI. That is government institution. But for BDS, my lord, he could have been my lord.
No, that the petitioner that the petitioner
Lordship will see the my lord second para.
In this context, it may
In
be.
this context.
that the cutoff mark
Yes. Cut off.
for your category in government school quota
Yes.
for admission into the MBBS was 564.
And petitioner is 563.
And as the petitioner had obtained the only 563, he could not be accommodated
Right.
into the MBBS,
Right.
correct?
Yes.
Correct.
However, the case of the petitioner can be considered, isn't it?
Well,
Can
My
be,
lord, no, my lord, Lordship will see. However, the case of the petitioner could not be considered for BDS course under the GI category because of non-receipt of inquiry
however,
report.
the case of the petitioner could not be considered
Lordship will see the third line of the first para
for
at
the
the bottom.
BDS course
Yes. Lordship
due
will see the
to
third line, my lord, in the
due
first para.
to due to
But his educational credentials of class 11 and 12 were not received from the concerned authority in secondary education.
due to what is it?
Third
Due
line
to,
of the first para from the bottom.
due
third line.
to non-receipt of his educational credentials
Yes.
for of class 11 and 12
My lord.
from the concerned authority.
Then
from
director of
the
secondary education.
concerned authority, i.e. the
Director of secondary education.
Director
Of
of
secondary.
Secondary Education Department.
Okay.
Stop. He further submits that the last round of counseling is
No, counseling is over, but admission is going on. If
That
there is any
the-
stray vacancy today,
that
it can be accommodated.
the admission, that the last date of his admission
Yes.
is today.
Today.
And in the event, if there's any stray vacancy
In BDS course, my lord,
under
any
the,
category.
in the BDS course, under any category.
No, under any category, there lordship will direct, my lord. We cannot say that under any
Okay,
category.
and
If
if
any
there's
vacancy, my
any
lord?
vacancy in the BDS course, the petitioner may-
Under UR GI category.
under the UR
GI. GI. In bracket
comma
GI.
GI category, the petitioner may be directed to approach the Director of Medical Education,
today.
Assam, today itself. Before?
But but during the course of the day, because counseling is, admission is going on today.
Okay.
By evening, my lord, they will wait.
Within the office today itself, within office working hours. Okay. Stop. For recording the submission made by the London Standing Council Health Department, comma, petition is directed to approach the Director of Medical Education, Assam, within the course of the day. Stop. In the event, comma, the petitioner appears before the Director of Medical Education, Assam, comma, and Assam, the case of the petitioner may be considered for admission under the BDS for the BDS course under any category.
Yes.
Under any category.
As my lord, the seat will ultimately go.
Subject to production of the educational credentials with regard to class 11 and 12.
No, my lord, that report will have to come from secondary department. So, my lord, also will make it subject to outcome of receiving it from the secondary, my lord, education
Subject to
department.
the outcome, subject
Say in subsequent time, my lord.
subject to the condition that the educational credentials of the petitioner with regard to class 11 and 12 are received from the Directorate of
What I would say, my lord, today he will have the admission. And this admission will be subject to outcome of receiving of the. In
Oh,
future, we will get.
you want that thing
It will have to be there, otherwise it will be difficult.
in the event, the petitioner approaches the Director of Medical Education, Assam, comma. The case of the petitioner may be considered for admission in the BTS course under any category. Stop. However, such admission should be subject to the receipt of the educational credentials of class 11 and class 12 from the Directorate of Secondary Education. When do you want? Monday? Or
Let it be tomorrow, day after tomorrow. I will just place it whether he has got the admission or not.
yes, the matter of
On that point.
today is 5th.
Yes.
7th.
My lord, this copy, if, my lord, possible.
Yes, my lord. Because I can also.
Then you do one thing. As the order is passed in the presence of Mr. B. Gogol, London Standing Council Health Department, he is requested to intimate the Director of Medical Education.
My lord, also will say the office of the director, because director is out of station, joint director will be available.
Okay, he's requested to intimate the office of the Directorate of Medical Education. Portrait.
Okay.
Yesterday, what happened?
By yesterday, my lord, so far as the seats are concerned, my lord, all has been filled up by online.
No, about yesterday's case.
Yes, but that, my lord, today it is coming up as unlisted, my lord, motion.
Oh, how about Converse case?
That part, my lord, she has been admitted.
Oh,
She has
you
been-
have
she-
sent the
she has been-
message?
Yes.
Because I could sign the order very late.
No, I immediately informed, my lord.
Okay.
Yes.
Okay.
5 minutes.
Pursuing fifth semester, 3-year course, my lord. My lord, pursuant to a impugned order, my lord, I have been debarred from attending classes.
Where the order?
My lord would kindly have page 43 of the writ petition, my lord. May I read, my lord?
Yes.
It is to notify all concerned that a joint reply to the show cause notice was submitted by Sri Parmananda Soikia, that is me, and Parvez Musharraf Hussain on 5/9/24. And on perusal of the reply, it is found that you failed to give the explanation of all the charges leveled against you. You had submitted an application on 31/8/24 at 2:50 p.m. seeking permission to reorganize the freshman social 2024-25. So again, you have crossed the limit to mislead the students and college authority. You captured the stage and did not allow even to welcome the newcomer students of the college. The other functions like introductions with newcomers, cultural program could not be held only because of few students led by you. After issuing notice and repeated communications on 22/8/24, you have finally submitted the expenditure statement of college week with justifications for excess expenditure in some heads. On 31/8/24 at around 1 p.m., Principal IC along with other teachers came to the stage, requested you to vacate the stage so that program could be started and gave assurance in the stage in microphone and in front of all students to release your remaining amount of college week by coming Tuesday, that is on 3/9/24, but you paid no heed neither to the principal IC nor to the other teachers and did not allow the program. Not a single program you had allowed to held, and now in your reply you have stated the program went ahead. Each and every one of us present student enjoyed the freshman program. It is really shocking with a double standard role played by you on the one hand submitting the application to reorganize freshman social and the other hand stating that the program went ahead and all the students enjoyed the freshman program. My lord, now the disciplinary actions which were imposed against us in the same page, my lord. One, restricted his entry to attend classes of the current session, that is LLB 5th semester, restricted his entry to appear for any internal assessment examination, including sessional examination, seminar, and viva of the current session, that is LLB 5th semester, restricted his entry to attend any program, function, event, and festival held in the college premises for the current session, that is LLB 5th semester, restricted his entry to appear for the end semester examination for the current session. His selection to Tezpur Law College Student Union 2024-2025 will automatically be vacated. My lord, the entire gamut of the situation arises. My lord, what happened is that I am a vice president of the student body, my lord, of the said college. My lord, during April, my lord, there was a annual college week, my lord. For that, there was a requirement of over 2 lakhs rupees for the expenditure, which was agreed to by the authorities. Now, my lord, what had happened is that we were given a sum of only rupees 1,28,000, and we were told at that time that we will repay it to you. You manage it now. Now, my lord, what we had to do at that point of time is that we had to borrow money from a fellow student, an amount of rupees 30,000 from here and there we borrowed and we organized the said event. After that, my lord, for the next 3-4 months, we were given assurance we'll pay it today, tomorrow, this way. Now, my lord, what had happened is that on 31/8/2024, when the said incident had occurred, my lord, we had in the most peaceful manner before the commencement of the said freshman program, we had gone to the stage before the commencement, my lord. We had gone to the stage and we had told that our dues are there, left, our dues are left. My lord, there is one more aspect to this, my lord. What had happened is that the fellow student from whom we had borrowed that rupees 30,000, his father died. And his elder brother, he had told us that you are not returning our money, we'll do a FIR, we'll file a FIR against you. So these pressures were against us. So in the most democratic manner, my lord, we had just expressed our opinion using our rights under Article 19, which in the most peaceful manner. Now, my lord, on second, my lord, we had got the impugned notice, my lord. My lord would kindly have page 38, my lord, the show cause notice. 38, my lord. May I read, my lord? To Paramananda Soikia, Vice President. In reference to the subject cited above and your conduct on 31/8/24, a group of students led by you stopped the program of freshman social, which was to be held in the college premises. All the set was ready, including stage, pandal, sound, musician, artist. Students were present in the pandal to participate and enjoy the program. And my lord, the said allegations which I had just mentioned in the impugned order, those has been leveled against us, my lord. Thereafter, yes. May I proceed, my lord?
Yes.
Thereafter, we had filed a reply, my lord. We were given a permission to file a reply. And my lord would kindly have page 39 for a moment, my lord. This is vital. Page 39. This is the part of the said show cause. You are hereby directed to submit a written explanation as to why disciplinary action should not be taken against you under provisions of discipline of the Guwahati University regulations. Now, my lord, they follow the Guwahati University regulations in letter and spirit. Now, my lord, we had filed a reply, my lord, at page 40. My lord has it. My lord, the explanations just what I had just narrated some time back, those are our justifications in the said reply, my lord. I'll not trouble the honorable court with that again. That is the point, my lord, that we had borrowed the money and everything, and in the most peaceful manner, we had expressed our and ventilated our grievances. Now, my lord, what has happened is that, my lord, the authorities thereafter, my lord, because this order was passed, my lord, we had approached the DC of Tezpur, my lord, where the said college is there. My lord would kindly have page 46 for a moment, my lord. 46. To the District Commissioner, Tezpur, Honitpur, Assam, we had ventilated our grievance, my lord. That portion only, my lord, that we had to borrow money and everything, and we had to conduct the said annual college week. That was our grievance. And in lieu of this, my lord, the DC had directed his department personnel to conduct an enquiry to this, my lord. So an enquiry was conducted, my lord. My lord would have at page 48, my lord, the letter, my lord, to the letter by Executive Magistrate Honitpur, which was forwarded to Additional District Commissioner, submissions of Magistral Enquiry Report. My lord, if I may read, my lord, page 48. With reference to the subject cited above, I have the honor to submit herewith the Magistral Enquiry Report, order number so and so, dated 29/24, regarding letter received from the petitioner Parmananda Hoikia, Parvez M. Hussain, and others regarding complaint against principal of Tezpur Law College, Honitpur. Thereafter, my lord, an enquiry report, my lord, was submitted by the said authority, the Executive Magistrate Honitpur, my lord, which my lord would kindly have at page 49, my lord, Annexure 11, my lord. Enquiry report, my lord, against us. May I read the relevant portion, my lord? Relevant portion is at page 50, my lord. Pointer 4, my lord, of the said enquiry. May I read, my lord? It can be certainly agreed that the suspended students were guilty of indiscipline, but denying them the right to give semester exam is too grave a punishment for the act committed during freshman social. The quantum of punishment meted out is not in proportion to the offense committed. This has severely violated the principle of proportionality on which Indian laws and Guwahati University rules are based. Moreover, the punishment should reflect the gravity of offense and societal interest, which warrants reintegration of the offense committed into the society. However, in this case, it was not found to be. It must be mentioned herewith that they have already been suspended from their positions in the student union body, which is already a punishment in itself. Now, my lord, I was holding the post of vice president. That was also gone by the impugned order. Thereafter, my lord, at page 51, my lord.
Where's the type copy of this, page 49?
Page 49 type. My lord, type copy is not there. This is the main enquiry.
But observation number 3 is not complete.
My lord, this much only we got, my lord. Oh, it will cut.
Okay, then.
I'm sorry, my lord. Thereafter, my lord would kindly have annexed.
What is the role of the deputy commissioner in such matters?
My lord, there is actually no role, my lord. I would come to the main regulations, my lord. If I may kindly take my lord's attention to the rules, my lord, which govern such indiscipline. My lord would kindly have page 73, my lord. 70, sorry, my lord. Rules of Residence, Health and Disciplinary Board, Guwahati University. That is the rules and regulations which govern such kind of indisciplinary act. Page 7070, my lord. 69, it starts. Rules of Residence, Health and Discipline Board, Guwahati University. Under this only, my lord, the said penalty was imposed against us, my lord. At page 72, my lord, would kindly have the relevant portion is there, my lord, which was not followed, my lord. There were procedural lapses as we are alleging, my lord. 72. My lord, may I read, my lord?
Yes.
Yes. Point 4, composition of the RH and D board. Dean of faculty to which a student belongs against whom. This is the composition, my lord. There should be a proper board, my lord. However, in the most arbitrary manner, my lord, the principal IC had herself taken cognizance of the matter without constituting a board and following the procedural mandates which I would be reading out, my lord, and had passed the said impugned order. In the composition, in the board, my lord, the following members should be there. Dean of the faculty to which a student belongs against whom case/complaint has been lodged. Concerned head of the department to when a sticking belongs whom a case complaint has been lodged. Reverend and warden of the concerned hostels to which students belong. A member of the EC to be nominated by the BIC/EC. One senior teacher from the Department of Law and GU. Law College, GU to be invited as and when felt necessary. Director and secretary. Apart from that, my lord, there is a due process of investigation, my lord, which was not taken place, which did not take place in my case, my lord. On receipt of, it is there only, my lord, in that page 72 only. On receipt of information regarding alleged indiscipline by any students, preliminary investigation will be conducted jointly by the dean of the respective faculties, head of respective departments, respective wardens in presence of departmental representatives and prefect, whichever is applicable. A report of the findings of the preliminary inquiry as mentioned in point 5 will be sent to the convener of the RH and D board. Convener will issue, if necessary, show cause notice against whom a complaint has been lodged and about whom a report has been received as mentioned in point 5, if with a copy to the guardian of the student to proceed further. Alternatively, the convener may dispose of the matter at this stage in consultation with the vice chancellor if the reply to the show cause notice is found to be satisfactory. If proceeded further, the RNH board will hear and record the statements of the students and any concerned individual as witnesses, which will be videographed. My lord, this was not followed. My lord, a copy was not given to our guardian, it was not videographed.
Lord, Guwahati University is only an affiliating institution, university. Lord, it's purely an internal matter of the school operator. But in spite of that, my lord, being a court officer, my lord, one thing is missing, my lord. Page 44, second para, that hearing part. So called notice was given. Charges were framed. Reply given, but no hearing. Punishment imposed. That hearing part, my lord, which is the spirit of our rules, my lord. And these principles of natural justice as per Supreme Court, my lord, is all are getting now nowadays. That part is missing. So cause notice, reply given, punishment imposed within 5 days. That's my submission. Otherwise, it's purely internal matter of the school law.
Is the college a party?
Yes, my lord, the college is the party, my lord. My lord, the principal, the registrar, and the principal IC, all of them are made party, my lord. The memorandum of parties, my lord, page 5, respondents 8, 9, and 10.
You are not appearing for 8, 9, and 10, Fukan?
No.
You are only for the Guwahati.
Guwahati University, 3 and 4. 3 is the vice chancellor, 4 is the registrar.
My lord, may I kindly submit one more point, my lord?
Yes.
My lord, nobody can be a judge in his own case, my lord. In this instant case, my lord, the principal IC has exceeded her powers, my lord. The body has to be considered.
The principles of natural justice is coming to your rescue only.
Yes, my lord.
Otherwise, you're also not very,
My lord, my lord.
whatever you've done, you have not done it properly.
Yes, my lord.
What were you saying? You're having your what?
My lord, I am
Semester.
having I am having my exams, my lord. I have to submit one professional. My lord would kindly have the notice dated 8/10/24. My lord, my professional ethics paper, which I have to submit on 10/11/24, on or before, without fail, it is written there.
8, 10.
My lord, 8/10/24 notice, my lord. My lord has it, my lord. Yesterday I had handed it over. My lord, there it is written that the professional ethics paper, my lord, I have to submit it before 10/11/24, being a student of fifth semester, my lord. That I have, my lord. And one more notice is there, my lord, 20/08/24. Therein, my lord, it is categorically stated that the first sessional exams I have missed, my lord, owing to the suspension, my lord. But the second sessional exams are going to start from 16/11. So that I may be allowed, my lord.
Why are you coming so late?
My lord, my lord, the students, my lord, they thought that, my lord, they don't have knowledge, my lord. That is why pursuing the matter.
Now see, you have already missed the first sessional exam.
Yes, my lord.
What's the point of having sitting for the second session?
My lord, otherwise there will be lot of backlogs. With my humble understanding, my lord. Otherwise the backlogs will carry on, my lord. Already there are some backlogs because I have missed the first. Second, I may be allowed, my lord.
Are you attending classes?
No, my lord. We have not, as per the impugned order, my lord, we have been barred from attending college, my lord. In fact, my lord, to our utter dismay, they have passed another impugned notice saying on 23/9/24, stating that the restrictions imposed upon us as per the impugned order that may be strictly followed. So we are abiding by that, my lord.
Where is that notice?
My lord would kindly have page 53, my lord. Page 53 of the writ petition, my lord. 53. May I read, my lord? (23/9/24) notice, impugned notice.
How many petitioners?
My lord, one.
How about the other one?
My lord, he is not approached. Not approached me, my lord.
Okay. Third, Mr. P.R. Shawal and counsel for the petition. Stop. Consequence to an incident that took place on 31/8/2024 with regard to the program of freshman social in the Tezpur Law College, comma, Tezpur Law College, Tezpur.
Tezpur Law College, Tezpur.
Tezpur. The petitioner was issued a show cause notice on 2/9/2024 on 6 different charges, and he was asked to give his reply within a period of 48 hours from the 48 hours stop. Accordingly, comma, the petitioner replied to the show cause notice on 5/9/2024. Stop. Thereafter, comma, don't select, the petition was issued in Ashok on 2/9/2024 by the principal in charge, by the principal in charge, Tezpur Law College. Draft. The principal in charge, Tezpur Law College, pass a notice on 7/9/2024, whereby disciplinary action was taken against the petitioner, and the said disciplinary actions are reproduced here and below. Page 44. A to stop. Para. It is the case of the learned counsel petition that after the show cause notice dated 2/9/2024 was issued, the petitioner has made his reply on 5/9/2024. Stop. However, without affording any opportunity of hearing to the petition, the said disciplinary action was taken against the petitioner by the notice dated 7/9/2024. Stop. He submits that the Tezpur Law College is following the
My lord, the Guwahati University, my lord,
is following the
my lord,
following the
Guwahati rules of residence,
following the rules of residence,
health,
health and discipline board of the Guwahati University in letter and spirit. Stop. However, the process leading to the disciplinary action against the petitioner has been done in total violation of the set rules. Stop. Para. Issue notice. Higher education, Mr. S. Buyan, and Standing Council Higher Education, appears for respondents 1 and 2. Mr. P.G. Fukan, and Standing Council Guwahati University, appears for the respondents 3 and 4. District Commissioner, M.S. D.D. Barman, Learned Additional Senior Government Advocate, appears for the respond number 5, 6, and 7. Extra copies. Petitioner to take steps for service of notice on respondents 8, 9, and 10 by registered post AD within 1 week from today. List the matter after 4 weeks.
my lord, end semester, with due respect, my lord, end semester exams are approaching, my lord. 1 month left, my lord. December session is already started.
When is the end semester?
My lord, the notification is not out yet. Usually it takes place during December, my lord, as per the academic calendar. Because sessionals are going to, second sessional are starting from 16/11, my lord. Thereafter, the end semester exams will start.
I'm suspending only 1, 2, and 4.
My lord, prayer, my lord.
Yeah.
My lord.
No, the disciplinary action 1, 2, and 4, not 3 and 5. 3 and 5, I'm allowing it to continue.
My lord.
In the entry, the disciplinary action at serial number 1, 2, and 4. Content in the notice dated 7/9/2024, issued by the principal in charge, Dismissal Law College, shall remain suspended till the next suitable notice.
Deeply obliged, ma'am.
22.
May I speak, your lordship? 22, item 22 is incomplete, lordship. Impugned order, he has not annexed, lordship. Only first copy he has annexed, second copy and our service copy, he has not annexed.
Where's the impugned order?
Impugned order page 21, my lord.
Here is no page 21 and second copy and service copy.
Second copy also you have not annexed.
Not annexed.
In the court's copy, you have not annexed.
First copy annexed, lordship.
Oh,
First copy annexed, second copy and our service copy, non annexed.
I finished now.
He also not received, I am also.
I
not
finished.
you finish him.
I given this one. I'll give the complete copy.
Let him file, give us a complete copy, lordship.
I will give the complete copy. Now, lordship matter is there is some mistake.
Let him first,
Mr. J. Ahmed, learned counsel for the petition, shall furnish a copy of the order dated 28/10/2024, issued by the District Mission Coordinator, SSC Kokracha, to the Learned Standing Council,
Today itself I'll do.
Elementary Education Department, as well as the Learned Standing Council, BDC, within the course of the day. Stop it.
Tomorrow matter will take
Please,
up.
not tomorrow. Least on Friday, 8.
Products on this item 1.
My lord, it may be taken up tomorrow, my lord.
No.
Then day after tomorrow, agency is there.
You have not done your part.
My lord, I'm sorry, my lord.
Wait for Friday.
I know this matter may be taken up at 2, my lord. Actually, Gogor will, my lord, we have actually received the copy very recently.
Okay, fine, madam, no problem. I leave.
Item 2.
No, it's written 2 p.m. The production.
Yes. Wait, please, your lordship.
What is this?
My lord, as per the honorable court's order, my lord, the medical board has.
Where's the order passed by this court? You have not annexed.
My lordship, today morning only after filing case.
That part I can understand. It was
Yes,
uploaded
yes.
quite late.
Yes, my lordship. Ito pa, ito pa. From para 10, my lord.
11.
Yes, my lordship.
Okay.
And my lord.
Where's the report?
Report, my lordship, before going into the report, may I quickly, my lord, place some factual aspects of this particular case? Yes, my lord, I understand I'm not a doctor, my lord. But being a layman, my lord, I can, my lord, find out, my lord, the anomalies, my lord. That may I place before your lordship, my lord. Page 32, my lord, of the writ petition, initially, my lord, very inception, on the basis of.
See, counsel, we have gone through all this yesterday.
My
And
lord,
then this court has passed an order
my lordship,
directing you to appear before the medical
My
board,
lordship.
who will
my
consider.
lordship, my
From
lordship.
that stage only you start.
Yes,
There's
my
no
lord.
point of going back.
My lord, to come to that, my lord, I have to, my lord, place the, my lord, the visual impairment, my lord, the criteria, my lord.
Okay.
The page 32, my lord.
32.
I'll make it very brief, my lord. Page 32 is the initial certificate, my lord. This was the medical examination issued to me, my lord. This Guwahati Medical College Hospital medical certificate, my lord, below. Month with effect from below that, my lord, 6/36, 6/24. Eyesight, my lord. My lordship has got it. Then, my lord, medical examination was done by the Guwahati Medical College, my lord, and an affidavit to that effect was also filed. And my lord, because this is a little bit voluminous, so I I couldn't fix it, annex it, my lord. Sorry to the option. Page 120. Page 120, page 120, 120, 120, 120.
You have to report?
Well, even a mail, my lord, Nadia Tawachi, covering this.
I've made a printout, my lord. I'll place it. I have made a
Okay,
printout for
then
it.
submit.
Yes. Here. I need to copy it. Huh? Photo. Hmm? No division. How division? My lord, page 121. Page 120. এখন দিলে না? Affidavit খন দিছে? Six 36, 624. Page 32 of my writ petition, I cite 636, 624. Then, my lord, page 120 of the affidavit, my lord, I just placed it before lordship. This is the board's comment sheet. 121 is relevant, my lord. Serial number 63. This is 624, right eye, left eye, 636. Then, my lord, this was again subjected to medical examination by AIMS, my lord. Then, my lord, serial number 7, Nadia Tabassum, right eye 636, left eye 624. Then, my lord, my lordship may kindly come to the examination that has been done. That recent. My lord, this is the report, my lord. I was subjected to examination yesterday, my lord. My lordship may kindly see distance vision without glass. In the top, it is written, one page number is there, my lord, 158.
Where?
My lord, third page of the report, my lord.
Yes.
Re-examination. This is, my lord, distance without glass. And below, my lord, distance vision with glass. So distance vision without glass, my lordship may see right, left, 636, 660, my lord. And there is even, my lord, overwriting over 620, my lord, 660 it is written. Then, my lord, below distance vision with glass 624, 636. AIMS, my medical examination, it is saying 624, 636. The medical board of Guwahati Medical College, my lord, it finds, my lord, 624, 636. AIMS, it finds, my lord, 624, 636. Here, my lord, for the first time, they finds the distance vision without glass, my lord, 636, 660, with that too, with, my lord, this overwriting is there, my lord. And then by using this distance vision with glass, it comes down to 624 to 636. 624 to 636 is 40%, my lord. All the reports are saying that 636, 624, right eye, left eye, my lord. And then this report, my lord, distance vision without glass, it has, my lord, they have, my lord, exceeded, my lord, 636 and 630, that too with, my lord, overwriting in the examination, my lord. One aspect gets clarified, my lord, that if by using, my lord, vision aids, my lord, advanced vision aids,
it gets reduced, my lord. My submission from the very inception is that I have low vision 8, my lord, 626, 624, 636. By using low vision 8, it comes down, my lord. This report says that, my lord, it comes down. But, my lord, the upper part, my lord, distance without vision without glass, my lord, it extended, my lord. How that can be, my lord? It is in contradiction with their own report as well as the report of the AIMS, my lord. That AR also part, provisional diagnosis part also, my lord. AR, if there is overwriting, my lordship may kindly see 2 point, this ought to have been 0.5. They made it 2, my lord. And all this subsequently, my lord, distance vision without glass, they have made it 660. Then, my lord, AR also.
Come to the previous page before
Yes,
that.
second page is the main report of the board.
My lord, report of this one, my lord. Second page. Second page is, my lord, type copy of this one, my lord.
No, it's a report by all the.
With glass 624, 636.
What I say.
This is without glass, my lord. Again, right eye 636, left eye 660, my lord. That is in contradiction with their own report as well as the report of the AIMS, my lord. And the direction of the Honorable Court was to see whether it can be brought down, my lord. This report also, my lord. Wherefrom they had got 636 and 660 for the first time, my lord. When their own report, it says 624, 636 when they conducted first examination. Then AIMS, my lord, 624, 636. For the first time without glass, they are saying 636 and 660, my lord.
After correction?
After correction, my lord, 624, 636.
Yes.
That is my vision without glass, my lord. And by applying low vision aids, it has to come down below that, my lord, which gets clarified from this report itself. If it reduces from 636, 660 to 624, 636. If my vision is 624, 636, then definitely with the use of low vision aids, it will
What is
get down.
this notification?
Lordship will, well, let him finish, my lord. Otherwise, my lord, we have followed the notification of 2024, 12th of March 24. Lordship will find that in the, is not been numbered in the fourth page.
My lord, the notification is there. I am not challenging the
I will
notification.
make my submission.
I have no issue with the notification. But, my lord, what about the finding of this report, my lord?
My lord, may I clarify regarding the finding, my lord? Why it is, my lord, even after, my lord, correction, why they have recorded it? Because in the bold letter we have stated, after glass correction, her in the page, second page, my lord, after glass correction, her visual impairment is 40%. Again, why we have stated, my lord?
It has to be 40%, my lord.
After
Because my
correction,
visual,
it has been brought down, then
without,
also it is 40%.
without
similarly.
any visual aid, it is, my lord, 624, 636.
Oh, after glass correction,
For the
heading
first,
is
yes.
very clear.
No, that is this for the first time they have written,
That
my
is
lord.
what
And that too, my
overwriting
lord, why this overwriting into the finding, my
He
lord?
can, my lord, bring this up to some, my lord, civil court or trial court, my lord. There's a different issue, my lord. In the read court, my lord, whatever direction
But
was made,
what is
appears,
apparent?
my lord. And even today, my lord, I have
That-
talked with the director of medical
that-
education. My lord, the concerned officer, my lord, lordship will see in the second page, Dr. Bharati Devi Borua, ophthalmologist. She has conducted the test yesterday also, in the earlier occasion also, she is there in the board. Today, she will appear to, my lord, before the honorable court, and she will explain this particular report because it's a technical part, my lord. Later appear, my lord.
Why shall appear, my lord?
Why not, my lord?
It is apparent on the face of the record,
How it
my
is
lord.
apparent, my lord? It says, my lord, after glass correction, it is 40%.
Three
It has been brought
medical
down, my lord.
examination.
And lordship may kindly see.
Three number of medical examinations. You are giving one report, and all of a sudden, they have given a separate report, my lord. I am placing it from the face from the record, my
In the
lord.
7th page.
I am a layman, my lord. I am not a doctor.
That's why
Yes,
you
my
are
lord.
not layman,
But, my lord,
medical.
as a layman, my lord, even a layman can understand, my lord, that this should be, my lord, that it has to be, my lord, 624, 636. For the first time, they have got it 636 and 660. That too by overwriting it, my lord.
There's no overwriting.
My lordship may kindly see without.
Maybe in the third page, but in the second page.
Second page is the typed copy of the report, my lord. Third copy is the re-examination. This is the examination has been done, my lord. Whatever may be, my lord. Even if for a moment I said that there is no overwriting. Then also, my lord, where from they have got this one, my lord? Then what is the report from the aims, my lord?
After
Aims of the
correction-
report, my lord, they're the
after
independent body,
correction,
they are saying, my lord, 624, 636. Then their own medical board, it is saying 624, 636. Now they are saying, my lord, 636 and 660.
Okay.
Yeah, may I, my lord? Lordship will see in the second page now, my lord. After correction, before that, my lord, whole part, after correction. Distant vision, my lord, right eye 624, left eye 636. So Lordship will see the chart now, my lord, how they have assessed it, my lord. Lordship will see, my lord, the chart, my lord. This is the chart, how, my lord, how to, my lord, ascertain the percentage.
See, this chart is not clear. I don't know.
No, that's I want to point out. Lordship will see, my lord. So far as my lord, the left side part is concerned, this chart, my lord, says 666, 624, 636. This is for the right eye. And my lord, at the top, my lord, these are for the left eye. Now Lordship will see 624 from the right eye. Then Lordship will see, my lord, 636 from the left eye. And if we go, my lord, we join these two, my lord, it comes to 40%. So this is the chart we have to follow. Even, my lord, after using the, my lord, glass or that, my lord, device, C comes within the zone, my lord. There is a particular slab,
My lordship.
C comes within 40%. Even after using corrective device. That's why repeatedly, my lord, all 3 times, my lord. In fact, this is the 4th time. My lord, it has come up that C has, my lord, 40% disability. Even after using glass. But we have nothing personal against this petitioner, my lord. We have nothing personal. That's why I'm saying, my lord,
It is very
let-
personal, it seems.
No. If she is eligible, today also we can admit her. But how, my lord, she will have to show. Raising some confusion, my lord, every day will not, my lord, help her. These are confusion, my lord. She is a layman. In fact, I'm also a layman. In fact, the honorable court also doesn't have the
I'm not raising any confusion, my lord.
These are
I am
talking here, overheading here.
submitting
These are-
entirely on the basis of record.
Record
And the
and after
reports
correction, it is 40%.
submitted by them only, and the report submitted by the aims, my lord, which was constituted as per the direction of the honorable court, my lord. The very inception, from the my lord, medical examination report which I submitted, subsequently the medical examination board they have constituted, then, my lord, the medical board constituted by aims, my lord. All of them are saying, my lord, in unison that it is 624, 636. And now for the first time, in the upper side, my lord, they have, my lord, raised my eyesight. And then, my lord, then they are saying that by using this device, your eyesight reduces to this category. At the very inception, my argument was never this, my lord.
Wrong, my lord. How
Before
do you know?
coming into,
That's why
my
I'm
lord,
saying, my lord, let her appear, my lord. Today is the last day. I am not against her. Let her appear. She will explain how it was examined.
she will say, my lord, this, she'll give
That's why
explanation to
I
her
will
report.
explain.
I understand. But what about the report given by the aims? What about the
absolutely
report given by them? By constituting a medical board, my lord. It is not in consonance with their own report, as well as the report of the aims, my lord, constituted as per the direction of the honorable court, my lord. That is what my submission is. My case otherwise would have been, my lord, in a different, my lord, alternative argument. My case was that, my lord, my disability was this, and by using aids, my lord, whether it can be brought down, and, my lord, if my disability comes in the way of my admission, my lord. Here is a question of the fate. Students, my lord, future is concerned, my lord. It can't be violated like this, my lord. This act has been, my lord, enacted, taking into consideration, my lord, all these things, my lord.
To let her appear, my lord. They will explain, my lord. In fact,
This
it will
girl's
clear
life
to
is
us
at
all,
stake, my lord. Her entire career is at stake, my lord.
Let her come with me.
Yes, I will. Right now, I will.
My lord.
We'll see what happens.
My
lord.
Lordship can
I'm
answer some question in that.
I have
regard,
come with-
Otherwise, I am, my lord, again, I will have to seek instruction. Since today is the last day, something will have to be done today itself, my lord. Either he is right or we are wrong.
No, no, there is no question of right or wrong, my lord. There is question of record, my lord. What is there on record? It is before your
Record
lordship.
says that, my lord, after
And
seeing
the
this
examination
device,
done by an independent body, aims, and the examination
AIMS
now,
knows
my lord,
AIMS is 40%, my lord.
that is their report is not matching, my lord.
AIMS is against him. That's why Honorable Court said that for the last time also, tomorrow you appear.
Not against me, my lord. It was very much in my favor.
No.
And that is why, taking into consideration, it was directed that whether it can be brought down, my lord.
Can she come at 2?
Yes, yes, she will come. I will right now inform her. Let us try, at least she can give reply to the every queries by raised by the petitioner as well as the.
Sorry. Lordship, item number 6, can it be posted on Thursday? I have some today, I have some personal difficulties, my lord. After 2 o'clock, 6, my lord.
Okay, on request made by MSA Bujabara, then the council for the.
Thursday
Thursday will be difficult. We'll have it on 12th.
must be right.
Yes, Gogoi? I'm sorry, madam, we have to disturb you a lot. You have a lot of work, but then there's some issue which this court does not have the expertise, neither anyone. So just see, there's this petitioner who claims she has 40% visual impairment.
Yes.
Low vision. And accordingly, this court we have directed yesterday to let the medical board reconsider the matter in view of that annexure H1, appendix H1, where the what we call the visual aids will have to be applied to see if it can be brought down below 40%. So you have given the report.
Okay.
Just show her the.
I have the report.
Or she will take
In
out the
the-
third page.
Yeah.
Of the plan.
Now there is an argument coming from the other side.
Yes.
Saying that the distance vision without glass.
Yes.
Is 636 and 660.
Yes.
And with glass, it's 624 and 636.
Yes.
Now, according to the petitioner, as the visual impairment from the beginning was 40%.
Yes.
And if the visual aids are used, are applied, the 40% will naturally come down. So this is what this court wants to have a clarification, whether those visual aids were applied to the petitioner when this.
Okay. Previously, previously I was sick, it was with glass. With glass, her vision was 624 right eye and 636 left eye. Previously, when I was examining her on 2nd 2024. Okay. Again, yesterday I said her without glass. At that time, it was not written without glass previously. Only I check her with glass, with aid. Okay. Then now, this is without glass. Yesterday, I checked her without glass. Right eye vision is 636 and left eye 660. Okay. And with glass, vision is 624 and 636. Same. It was like previous reading. It was same. In the without glass, 636 and 660, it is also, this is also in the visual impairment also 40% and disability category 3 low vision. And with glass also category is same because she is wearing very low power glass, very normal glass, normal spectacle, very low power glass. Okay, it is not a low vision aid. This is a normal like our normal glass. Just wearing normal glass and she can able to write one line below. Okay, improvement of one line. So percentage is same. With glass percentage is also same. Without glass percentage is also same. Because she is an operated class patient. Both eye is operation is there.
Okay.
And
intraocular lens also implanted inside the eye. In that glass is also have power. This is normal. Cataract asile. She was having cataract. So it is not a low. I cannot say from according to guidelines that she is wearing that glass. This is low vision glass. If it is a low vision glass, it should be more than 12 diopter. It is 2 diopter glasses he is wearing. If it is more than 12 diopter, it is called.
So beyond this, you cannot bring it down by way of using other artificial or what you call the low vision aids. Can you bring it down below 40%?
Below 40%.
Is it possible? Not possible.
Not possible.
Not possible.
Not possible. Actually, wearing this glass, with this glass, she can able to read everything.
So the maximum is the maximum that can be done is that 40%.
40%.
Not below that.
Not below. If it is, if we give low vision and then it will be 30%. She can read more. It will be 30%. Then it will be a normal. Then it will not go in the category 40% category. If we try with a low vision aid with her, then it will be not 50 or 60%. It will be 30%. Then it will be. No, 30% is not included.
Yes. By using high power aid, vision aids.
High power
That is
aid.
what my lordship is asking me. That is the answer, man. It can brought down to 30%.
Get me the correct answer.
No.
I think there's something not properly. I'm not understanding.
No.
She was wearing.
No, actually, with wearing this glass, normal glass, with wearing this normal glass, she can read. No need to, but she is doing the day-to-day work. But in this line is there. The notice there that if it is vision is less than 40%, less than 40%, then if it is 50%, then wearing with using low visual aid, then it will go 40%. But without wearing this is 40%.
If this argument is to be accepted, my lord, then yes.
Let us be very clear. Let us. Yeah, Gogoi, you just explain it properly. Maybe my explanation was not proper. Both of you together can help her. Because
but with our department, we
with due permission, court is asking with the help of high power aid glasses. Then she will be able to read.
She cannot. It is amblyopia is there. She cannot.
Her visibility is 40%.
40%. She cannot.
And you are saying that the glass she was wearing,
it is normal.
she could read only few lines, isn't
One
it?
line.
Isn't
yes,
it?
Yes.
But if you apply your own devices, then it can improve.
No, it cannot improve because she is having operation is there and amblyopia is there, amblyopic eye. So she cannot. In that case, she cannot.
Then 30%.
Oh, people have
See, I think I've got it.
No.
My lord, if this argument would have to be accepted, then my lord, my yesterday's cases were, my lord, rejected it. My lord,
below 40.
with you.
No, those are below 40.
Below 40, yes, my lord.
See, here
she is saying that by using this aid, her eyesight is
40%.
40%.
By using the aids.
By using the aids.
Beyond that, it cannot come.
Earlier, whether
The
this
issue
report,
is petitioner had the cataract.
my lordship,
She had an operation.
my lordship,
plus she has put artificial lens inside her eyes.
My lord.
Correct?
Correct, yes.
That is what we normally say artificial lens.
This artificial lens also is a normal.
It's inserted in your
Normal.
eyes. On top of that, she's wearing the glass.
Glass.
Very low power.
Like
Low-
very low power. glass.
But that glass is the maximum power that you
Yes.
can give.
Yes.
No. That is
Yeah.
that she has not said, my lord.
No, actually, this power is actually she's amblyopia. She cannot. We apply the pinhole
So,
and all are there.
What is this? What you call
We
it?
are wearing here, my lord.
Oh.
Amblyopia, whatever.
The glass which we are wearing, my lord. These are normal glasses.
Even ours,
Earlier, my
if you
lord-
remove this, we cannot see anything.
No.
Just
Oh.
few
Normal.
minutes before she said 30%, I will not go into that, my lord. Whatever she has said, my lord. She must have not understood anything, or maybe, but she is an officer, my lord. Of
No, she is an
yes,
expert. She is
expert
an expert
in this
so-
field, my lord. So I cannot comment
So,
above her finding, my lord. My submission would be, my lord, same medical officer submitted a report before this honorable court. Her signature is also there in this report. She said, my lord, right
With
eye
glass. That was with glass.
with glass, then
With glass.
if
Same,
with glass, my lord, this observation is there.
yes.
Then others would have had also been examined with glass, my lord. Then it was below 40%. Then my other petitions were rejected not correctly, my lord. If this argument has to be accepted, if with glass, my lord.
It will come, my lord, this note will come only when someone is found to be more than 40. They were below 40, some 14%, some 10%.
They were,
We cannot
they were
give, my
having
lord,
10%,
I
10%, 14%.
must read it again.
And therefore, this court said
30% is
that-
also there, my lord.
that
30% was also
the
there.
those petitioners would be entitled
For MBBS.
for MBBS, but not within the PWD quota.
Oh, yes.
My lord, that is
Not within the
with
PWD.
use of device, it has to be below 40, my lord. That was the criteria, my lord. I'll not
Low
put any
vision.
absurd submissions before this honorable court. My submission is very clear, my lord. The report she has submitted once, my lord. This report, my lord, same finding, AIMS has got it. Honorable court has come to a finding that it was not used. It was, this finding has not been arrived by using high visual aids. And that is why a direction was given to them that you do examination again. Then, my lord, this examination, now they are saying, my lord, that earlier I was having, my lord, a higher range of eyesight, my lord, impairment, that is 636, 660. Now by applying this high power H, my lord, that is as per appendix H1, it has come down to 624, 636. Then, my lord, what about the report that has been submitted by Madam only earlier occasion, wherein her signature is also there?
That is what
Wherein-
he's saying. That was with the applying the issue is this.
My lord.
In the first report, there was no
In the
proper
first-
explanation given.
Okay.
So this court, and then on your submission,
My lordship.
on your submission, we constituted that independent body.
AIMS.
Before the AIMS.
My lordship.
After that, again, you're not satisfied.
My lordship.
So this court said, okay, in terms of H1, appendix H1,
My lordship.
apply the apply the vision aids.
My lordship.
Vision aids, and then see whether the petitioner's disability can be brought down to below 40%.
Below 40%.
Now, what today she's saying is that applying the applying the visual aids would have to be with the specs only. If there are any other things, I don't know. But so far, yes, I understand.
My
It's
lord.
with the glasses.
This is not a normal case, my lord. My lordship is deciding a case wherein a differently able child
That is what
is seeking admission at par with able-bodied person, my lord.
correct.
And here is a situation, my lord, wherein this body already gave a report. I say, all right, this report now says saying that by applying low vision aids. She got this. Then there is a report from the AIMS also. Then that report, AIMS report, has also to be by using low vision aids. If all these reports were given by applying low vision aids already, that means they have already complied with Appendix H1.
Oh.
If that be the case, my lord, then that has to apply with other cases also, wherein in some case it is found 30%. That candidate must have had 40% disability, which was brought down to 30% by applying low vision aids. But that is that their submission was not that on the earlier date, my lord. That it was obtained by applying low vision aids. They are saying it today.
No.
They have not said on the report submitted by AIMS that they have already complied with Appendix H1. That they are submitting it today. And my lord, the entire complication arises because at para 11, my lordship has given a specific direction. You give a report. You record reasons as to how she is not entitled for a seat in medical course. No such
that part is there.
record is not there.
That part is there.
One,
That reasons has not been given.
I want to
Because
say one
my
thing.
case is, my lord.
Yes.
I want to say one thing. My my glasses say -1, -1. I can see with -1. If I put -5 in my eye with aided vision, I cannot see, it will be blurred. Same like this. If we add more glass, we add -2. Again, we are applying -3, -4. Then our eye is not accept.
Okay, Das.
Oh.
What are you wearing? Minus or plus?
Minus.
Minus.
Minus. This is normal eye, my lord.
No, that
That
no,
is what
same with me, same.
That's it.
You are having how much? What is your power?
Minus 2.5.
If we put 3,
3.
can you see?
No.
If you put 1, can you see?
No.
Because same with me, at least this experience I have.
My lordship.
I'm also having -2.
My lordship, correct.
If I put 3,
my lordship,
everything will become a little hazy.
Hazy. Correct.
And you can't walk also.
Correct, my lord.
Because something is not proper.
Correct. my
At
lord.
least that personal experience I have.
Correct, my lord. My lordship is correct. If
So
they
if-
put
if
3,
that-
4, 5 on me,
That
I
is-
cannot see.
So what is best for the patient?
Patient.
What is best? The doctor will prescribe.
But
So you got 2, I got 2.
But my
With
lord,
that we can
after
see.
having the medicine or after having my specs, it is only me who can say, my lord, that yes, Dr. Sir, I can read properly with these specs, my lord. That is one aspect. The other aspect, my case is I am a able-bodied person. I don't have any disability. I don't need any specialized devices to read anything, my lord.
No,
But
what are the
case-
specialized devices?
That she'll be best person to say, my lord, not
What
me.
are the other specialized devices apart from spectacles that you can use? That let us see
Whether
that H1.
it-
Show it. to
It
us.
is there in Guwahati Medical College or hospital, it is there or not? Those devices.
Devices, telescopic device and telescope device.
Yeah, magnifier.
Magnifying
What
glasses
is
also
what is
there.
this?
These are for very low visual, very low visual person. Those who cannot work without help. Then for that cases, that type of cases, we give the low vision aid that with the help of the other person, they work and just able to see somehow. But in that case, she can read and write and doing everything. She can do everything.
That means
With
her
the,
disability does not come on the way of her career.
with the
With the use of low vision aids, her disability does not come in the way of her career. She will be just like an able-bodied person, and she will be able to read and write just like any other person if this she gets proper, say, devices, my lord. Now the question in this particular case is whether this girl should suffer because of her disability or not. That is the question now, my lord.
Yes.
Because of her, whether her disability is coming on her way of her career.
Okay.
That is what I am trying to submit, my lord.
Yes.
This is actually what I found I present here. I am not coming here to argue. I
Yeah,
just
yeah, I
present
know.
what I
No.
what I get.
This court
What I get.
made
What
a
I get.
request to
I got previously, I got the same result, and now also I got the same result. But previously I didn't write the without glass vision. Previously I wrote only with glass vision. Previously I was not right the power of the glass previously, but it was a normal checkup. It was normal checkup, and a lot of students came at that day. Then we check each and everybody. It is not possible now. Again, on re-examination, I just check without glass and with glass and give the power also. This power is -2 and one is -1.75.
With due respect to the honorable court, and with due respect to the officer here, may I ask one question to her, madam?
yes.
Madam, see, this is the report you prepared, isn't it? I mean, you were one of the member while preparing this report. This is your signature, isn't it?
Yeah.
See, there is one candidate, Rahul Amin Laskar. His percentage visual impairment, you categorize it to be 30%, isn't it? So it was after use of low vision aids or before use of low vision aids? Because his disability was 40%.
Rahul Amin Laskar. I have to say, I forgot now. Actually, there's so many.
Because you are one of the member, that is why I'm
There are so
putting
many
it to
members.
you.
1, 2, 3, 4, 5, 6,
Yes, I
7.
understand.
We are
But you
seven,
are head of the
We are seven.
ophthalmologist and he is a person with
This is-
low
This
vision.
is a different case, or this is a different
No,
case.
I understand
I didn't
Yeah,
recall also that person.
See, the doctors
I
here
understand, my lord.
at the request of the court.
I understand, my lord.
Just to clarify
Yes,
some
yes,
things.
yes.
Otherwise, this is not a
Yes,
for
yes.
argument.
Yes, yes.
with
This
the
is not a
doctor.
trial court, madam. Absolutely,
not a-
absolutely.
I'm not.
I'm
permitting
so
that.
sorry, madam.
Anyway, I
I'm
did
so
not
sorry.
know. Anyway, since you have
I-
come, I think the doubts all out clear. Okay. Okay. Thank you. Thank you so much.
Thank you.
So, thank you so much.
She can leave. Oh, go let her go.
Thank you. So, my lord, what I am trying to submit.
See, these are very
This is unfortunate on the part of the petitioner, a young girl, my lord, who is, my lord, trying to, my lord, achieve her goals, my lord. She
See,
passed her matriculation, she passed
that's-
her high secondary,
that's
and
we have seen everything.
she succeeded in NEET UG exam also.
We understand that. We understand.
And now is a
Only
situation,
because of this disability.
disability.
Disability, she is unable to get into the.
No, my lord, that
into
is
the
not
course,
the case,
into
my
the
lord.
course that she is trying to get.
That,
Now, this court has tried to help the petitioner in every possible manner
my lord,
to see that there's no injustice done to the
I
petitioner,
appreciate that, my lord.
considering that it is a purely a beneficial legislation.
My lordship,
And therefore, we have taken some untoward steps also
My
for
lord.
doing this thing.
my lord.
But now today the doctor has come.
Doctor,
I
my
did
lord,
not want to say it in front of her.
if,
But then what they have failed to do is that in the first report, they did not say that these aids were used, and then with specs, without.
My lord,
In the second one, when this court order went,
Ames.
maybe, no, this
Yes, that is
particular
fine.
GMC.
Mm.
They may also have thought, okay, let us go without spectacles, with spectacles. And then I think she had a thorough check on the petitioner, where she found that she had cataract, there was an operation, and artificial lens also were are there in her eyes. And then she's having some term she used, something like that, which I can't remember now.
Term she has used.
And
Under that circumstances,
considering
my
all
lord,
this,
one aspect, my lord, what I am submitting before this honorable court, my lord, first report, there is no mention, I understand that. I understand, my lord. But it is not a case where her vision cannot be brought down.
how do you argue that? How do you
Yes,
get
my
to
lord. That is, my lordship may kindly see the report that she has submitted. Distance vision without glass.
Hmm.
636, 660. And distance vision with glass, that is brought down to 624, 636.
Correct. And that is 40%.
But I say, my lord, from the very inception, three authorities are saying her vision is 624, 636. And by applying this glass, it will come down, my lord. That is my submission, man.
No, here the glass has been applied. Glass has been applied. After that, it
Other
has come to
aims, my lord, without apply, because the certificate which I submitted before this honorable court, without applying glass, that is 624, 636. Now she said, okay, glass applied, my lord, subsequently. That again, same, my lord, eyesight. Aims, my lord, that has to be without glass. That is why my lordship has directed that you apply low vision aids. That is also, my lord, 624, 636. Then, my lord, they have raised the distance vision to 636, 660, my lord.
Okay.
So the only question, my lord, whether this disability, whatever may be, is whether hampering this candidate from pursuing her dreams, my lord.
Yeah.
Because it will never come as a hindrance, my lord.
So
If proper medical examination would have had been done, my lord, proper report would have had been given that because of this reason, we cannot give her, we cannot admit her in MBBS course. But in this particular case, no such report has been given against, my lord, the finding. Why not given, my lord? Because the finding is apparently doubtful, my lord. There is overwriting also.
where is it?
I didn't mention anything about overwriting before the officer present.
Where's the appendix H1, that notification?
Initially, it was never followed, my lord, till aims, my lord. It is at page. Only now, my lord, this has been followed. But I'm
Page 64
of the writ petition of the.
she's a deserving candidate, my lord. Student.
It's unfortunate.
In fact, my lord, this honorable court has done everything, my lord, to
We
at
have
least
tried
facilitate
everything,
my lord, some
every chance,
Yes. every endeavor has been made.
If this report, my lord, this distance vision without glass would have had been 624 by 636 as given by the aims and their own report, my lord, then this definitely would have come below and my chances would have been there, my lord, apparently. Now also, my lord, there is nothing on record which says that my disability comes on the way of her admission, my lord. In fact, rather, my lord, the officer herself has said, my lord, that by using some aids, my lord, it can be brought down. 30% in fact, she said, my lord. It is there on record, my lord. Now.
Where?
No, my lord, not on record otherwise, my lord.
If it comes under 30, still then you are not eligible.
No, my lord.
You will
6.24.
not come under the PWD quota.
Come, my lord. This is
How?
the last 624 and 636.
No.
Next is 618, my lord. 624 below is 618.
If it comes below 40, if it is
Six-
brought down to 40%, below 40%. Just see appendix page 54.
54. Below 40, my lord.
Oh.
Below 40, I get, my lord. Only by using low vision aids, my lord. Advanced low vision aids.
That
I
was
get, my
further
lord.
clarified that low
If-
vision aid, my lord, in this power, whatever CS, my lord, the power, my lord, -2. It cannot be used.
That
my lord.
interpretation, that submission cannot be, my lord,
This is not a criminal case. that
taken
my
into
lord tried,
consideration
but it will
because that is
cross-examine
nowhere
of
on
the
record,
and
my lord.
finding.
Everything is there. Submission has to be made on the basis of the record, my lord.
And my lord, the report may be challenged, my lord, she has every liberty. That's a different issue.
Report, my lord, today is the last date for this girl, my lord. Where she'll go from
Yes,
after
ma'am,
today, my
please.
lord?
Heard Mr. M.K. Das, learned counsel for the petition. Also heard Mr. P. Gogoi, learned standing counsel health department. For the respondents, 1, 2,
My lord, 1, 2, 4,
4,
5,
5, 6,
9, and my lord, 8, 9, and 10.
8, 9, and 10. And Mr. K. Gogoi, learned CGC.
For free, my lord.
For the respondents, 3 and 7, correct?
Yes.
3 and 7 also. Right.
Hmm?
3 and 7 also.
3 and 7, stop. Alright. The petitioner before this court is having a disability certificate. Where is she is shown to have where she is shown to be having 40%. Where is that certificate?
Page 29, my lord. On the basis of page 33 is the
Where she is having 40% permanent disability in relation to both her eyes. Within bracket, low vision. Issued by the Joint Director of Health Services, Ojai, Assam, on 29 to 2024.
So yesterday's order will cover almost half of the order. Same facts will Lordship will have to repeat that order. Madam.
Okay.
It's already there. Lordship will
Where is that?
indicate the pair side.
Lordship, I had already given.
Initial part are safe. He'll take 5.
Till 8.
No, copy today. Yes, yes.
Up to para 8. Up to para 8, you just copy them. Stop. Not being satisfied with the medical report, with the comments of the medical board, comma M's of Guwahati, The learned counsel for the petitioner submitted that the medical board, M's did not apply the visual aids as while assessing the disability of the petitioner in terms of Appendix H1
My lordship.
of the amendment notification dated 13th May 2014. Stop. Accordingly, accordingly, this court on 4/11/2024 directed that the Director of Medical Education, Assam, to facilitate the petitioner to appear before the medical board constituted by the principal cum chief superintendent, Guwahati Medical College and Hospital by office order dated 38/2024. And the petitioner was directed to appear before the said medical board on or before 5 p.m. on 4/11/2024. Stop. Para. In terms of the order dated 4/11/2024, the petitioner appeared before the medical board constituted by the principal cum chief superintendent, Guwahati Medical College and Hospital on 4/11/2024. Stop. However, as the findings of the said medical board continued to be the same, i.e. 40% visual 40% visual impairment. The petitioner has filed a present petition. Stop. Para. Mr. B. Gogoi, Learned Standing Counsel, Health Department, has produced the report of the medical board which assess the disability of the petitioner with regard to her with regard to her visual impairment. Stop. In the said report, it is indicated that without glass, the vision of the petitioner with regard to her right eye is 6/36 within bracket P, and her left eye is 6/60 within bracket P. Stop. Further, with the application of glass, the vision of the petitioner with regard to her right eye is 6/24 within bracket P, and her left eye is 6/36. Stop. The report, therefore, in the said report, it is stated that after glass correction, her visual impairment is 40%, and 40%, and her disability category is Roman 3, within bracket small a, within bracket low vision. Stop. The report further indicates that the percentage of disability is given as per the Gazette of India notification dated 12th March 2024. And what is this? And number stop MCI dash 34 within bracket 41 oblique 2018 dash MED oblique 170045 dated 4/2/2019. Stop. Para learned counsel for the petitioner submits that the the 40% disability in the second medical report that was held on 4/11/2024 is the same with regard to the first report, which was held on second, isn't it, on 2/9/2024, as well as that of the medical report of the AIMS Guwahati, which is an independent body. Therefore, comma, the visual impairment of the petitioner with the application of
Low vision aids.
advanced low vision aids would surely come down below 40%, thereby making her eligible for getting a seat in the MBBS for the MBBS course. Stop. But this court, not being an expert, nor the councils, this court, nor the councils being an expert in this field, comma, Mr. B. Gogoi, the Standing Council Health Department, was requested to to have the presence of Dr. Bharati Deori Borua, Professor of Ophthalmology, GMC and H, member Medical Board. To be present in court in order to rectify all the doubts that has arisen with regard to the visual impairment of the petitioner. Stop. Para. Of the petitioner, and the matter was that and the court fixed for taking up the matter at 2 p.m. today. Stop. Para. This court. No. Para. Stop. Dr. Bharati Deori Borua is present in court as requested, comma, and it is explained that the petitioner had a cataract operation in both her eyes, and she's also being implanted with an artificial with a, what you call that?
The lens.
With an artificial lens in her eyes. Stop. Apart from that, comma, she is using normal glasses, and accordingly, when the petitioner was assessed, comma, they had assessed her without the glass, and after application of glass. Stop. in the view of the in the view of the specialist who is present in court today, comma, the 40% visual impairment of the petitioner cannot be brought down. But this court has given an anxious consideration to the case in hand, particularly when it is dealing with a disabled person having low vision and is vying for a seat in the MBBS course in the under the Assam state quota. Stop. The anxiety, the considering the anxiety of the petitioner, this court had constituted, this court had requested the authorities in the AIMS to constitute a medical board to examine the petition with regard to her low impairment. Stop. In the said report, in the report of the medical board of AIMS Guwahati, her visual impairment is shown as 40%. Stop. However, as this court found that the petitioner was not satisfied with the opinion of the independent body, medical board AIMS, the court had directed on 4/11/2024 to the had directed on 4/11 had directed the director of medical education Assam on 4/11/2024 to facilitate the petitioner to appear before the medical board that was constituted on 29/10/2024. No, that was constituted on 2nd of September 2024. Stop. The report of the second examination of the petitioner also turns out to be the same, i.e. 40% visual impairment, 40% visual impairment. Stop. Under the circumstances,
40%
visual impairment.
visual impairment, that calculation, my lord. 40% calculation comes from this, my lord, I was submitting, my lord. That was the criteria. Vision equity, they say, my lord. Vision equity is, my lord, that 6/24, 6/36. That is the vision equity, my lord, on the basis of which this 40%, 30% is being calculated.
Okay.
So there is difference of vision equity in a, my lord, this present report, my lord. That is what I was trying to say.
What did I say? In the second report, the petitioner is found after correction. No, the petitioner after correction is found to have a distance vision of 6/24 within bracket P in regard to a right eye and 6/36 with regard to a left eye. Stop. Para. Under the circumstances, comma, this court is not in a position to give any views any further views with regard to the visual impairment of the petitioner against the reports of the experts. Spot. Accordingly, comma, this court does not see any merit in the writ petition and is accordingly dismissed.
Oblige me.
It's very sad. This is yours?
Yes, my lord.
Item 1 of production list, Dr. Sasanka Shekhar sir.
Is this IA? Wrong file. Yes.
Made big.
Yes,
Lordship.
that's
You know, this is a very small issue. Unnecessarily, it has been made big. You know, Lordship will kindly come to first page 29. Page 29 is the charge sheet. This was dated 21st December 2023. My lord, I'll not take your lordships with the charges because I am not on the merits of the case. I'll just take your lordships with the number of witnesses. That your lordship will find page 32. There are 24 witnesses in page 32.
okay.
Now, after the charge sheet was issued, I participated in the disciplinary proceeding, my lord. I asked for the documents and finally I filed a written statement of defense. That your lordship will find page 45. This is dated 3/7/2024.
Yes.
Written statement of defense. Then, my lords, the respondents issued this notification, page 69. Lordship Scott Miller. The governor of Assam is pleased to appoint Sri so-and-so, retired additional secretary, MPanel enquiry officer, member state enquiry officer panel, retired as enquiry officer, under the provisions of Rule 9(4) of Assam Service Disciplinary Appeal Rules 1964 to conduct an inquiry in the departmental proceeding drawn up against Sri so-and-so, associate professor on leave, Assam Engineering College, White show cause notice dated so-and-so, submit a report within 30 days from the receipt of this notification. Then by the same notification, my lord, 8A, the governor of Assam is further pleased to nominate Sri so-and-so, a joint director, Office of Director, Technical Education, Assam as presenting officer under the provisions of Rule 9(5) of Assam Service Discipline Appeal Rules 1964 for the above stated inquiry. So IO and PO were appointed. Immediately, there should have been opportunity given to me that if you want to engage defense assistant, you engage your defense assistant. No such opportunity was given. I submitted an application that your lordship will find page 71. This was an email to the disciplinary authority on 21st of August 2024. 13 August, my lord, IOPO was appointed. I submitted this email 21st of August 2024. It says, with due respect and honor, I hereby pray for allowing to nominate a defense assistant in my disciplinary proceeding. Then, my lord, in the same page itself, there is another email that is 15th September 2024, page 71. Milord, the second part.
That I've read.
Yes. Now, Lordship will kindly come to page 72, the last portion of that email. Folded and I request to allow me to avail the service of defense assistant in my departmental proceeding and do the needful for interest of justice. Details of the person I wish to avail service as defense assistant, name has been given, my lord. Sri Ranjit Goswami, retired conservator of forest. Now, this email was of, my lord, 21st of August and 15th September. The government, my lord, sat over this matter. No decision. In the meantime, my lord, what happened? The inquiry officer, my lord, gave notice of the hearing that your lordship will find page 75. September, my lord, I submitted the application suggesting the name. 18th September, my lord, sorry, 5th September, the IO issued this letter in inviting reference to the above. I am to inform you that the date of preliminary hearing of the above mentioned departmental proceeding is fixed on 18th September. So, the IO has started the hearing of the matter. Now, my lord, thereafter, I submitted another email, page 77, that is dated 19/9/2024, wherein I attached the consent letter of the defense assistant. Page 78, your lordship will find the attachment consent letter. And that particular consent letter, your lordship will find page 82.
What is this consent?
My lord, for engaging a defense assistant, my lord, a consent letter is required to be submitted that he consented to act as a defense assistant in the departmental proceeding. So that consent letter is at page 82. So he agreed that, okay, I'll be your defense assistant in your departmental proceeding. And that fact was intimated to the disciplinary authority on 19/9/2024 by email dated page 77. They again sat over the matter, my lord. Nothing has been done. Then, on the other hand, the inquiry officer, he again issued this communication, page 90. He issued this communication. It was marked down below to the petitioner, by which these 4 prosecution witnesses were directed to be remain present on 3rd of October 2024 for examination and cross-examination. That means the inquiry officer, without my lord, without presence of my defense assistant, without allowing a defense assistant in the DP, he has started the proceeding. Now, this is one date. Then, my lord.
What happened on 3rd?
On 3rd, my lord, these witnesses were examined by the PO, and I was compelled to cross-examine by the IO. The IO said, no, it's all right. The decision from the government will come, but now you do the cross-examination. Well, that is the situation. Thereafter, my lord, I again on 29 September, page 91, submitted an application reiterating my prayer that you allow me. I'll be seriously prejudiced in the DP if you don't allow me. This 29 September, page 91 is prior to this date of 3rd October. Then again they sat over the matter. Finally, after almost 1 month, they issued this communication, page 97.
Yes.
Page 97, my lord will find 18 October 2024 is the date. It says subject regarding availing the service of defense assistant in the disciplinary proceeding. With reference to the subject cited above, I am directed to inform that the government in the higher education department regrets the proposal for allowing Sri so-and-so to serve as defense assistant to your departmental proceeding as per provision of Rule 95 of Assam Service Discipline and Appeal Rules 1964, being a retired government servant. So they say that as per rule, a retired government servant cannot be a defense assistant, my lord. Well, fine, absolutely fine. If you are not allowing that person, then I'll have to arrange for some other person. So after this was given after 1 month, and in the meantime, the inquiry officer continued with the DP. My consent letter was of 1909. Now, your lordship will find page 98. The inquiry officer again fixed date of hearing on 24th, wherein 4 prosecution witnesses were directed to be remain present for examination and cross-examination. You know, same thing had happened again. Again, I was asked to cross-examine. Then page 100, there is another communication by the inquiry officer. Back-to-back hearing, my lord, 24th and 25th. This is, your lordship will find in the first paragraph, inform you that you have been cited as prosecution witness by so-and-so. The date of hearing of the appointment is 25 October 25. So this continued. These were of 18 October 2024 date. Now I submitted an application as well as another application, page 102. This was dated 21/10/2024, saying that since you have rejected my earlier defense assistant, I may be given some time so that I can arrange for a another person as my defense assistant. Then, my lord, on 21/10 itself, on 22/10/2024, on the very next day of submitting that representation, that your lordship will find page 107. I did not, my lord, waste a single day's time, my lord. 21/2, I submitted an application that allow me some time. On 22nd itself, page 107, I submitted this application suggesting the name of an in-service defense assistant. Proposed defense assistant, my lord will see. So you rejected the earlier one saying that he is a retired government servant. So I have given on the very next day, given this person, suggested this person to be my defense assistant and in-service person. Now, the consent letter of that defense, newly proposed defense assistant, 108. After all this, my lord, again disciplinary authority, my lord, set over the matter. Till date, there is no decision, and the inquiry officer has passed this impugn order, 115. In the meantime, my lord, I submitted repeated email to expedite the decision, but no action taken. 115, it says, again, 4 prosecution witnesses were asked. The date of hearing of the above mentioned departmental proceeding has been fixed on 6th November 2024. That is tomorrow. This was shown to be issued on 20th October 2024, but I received this yesterday only. That I have stated in my paragraph.
Why were you participating in those other sittings?
Previous, you know, that my
without having a
true
defenses.
Milord, first date was of 18. That was of preliminary inquiry. So on that particular date, Milord, normally the inquiry officer asks me what you want to say or whether you have received the documents and all these things. I don't have any problem in that. But 24/25 back-to-back hearing, Milord, I expected that there will be some decision with regard to engagement of my defense assistant. I asked the inquiry officer also that there is no decision by the government for appointment of DA. The inquiry officer said, let us proceed. He should have stopped there when the DA was not there.
Yes, Gogoi.
So if the proceeding continues, Miller, I'll be seriously prejudiced, Miller. It's an innocuous prayer.
What is the difficulty of giving him a
Regarding
defense?
Lossi, that particular to that already we have Lossi at course examine, that part we are not explained. Here Lossi, my brother is Lossi praying for providing the defense assistance. As per rule 9(5) Lossi, he is entitled. So Lossi may dispose of the matter, directing the authority to Lossi consider his application for appointing a defense assistant and then proceed with the proceeding. I am no objection that part. Otherwise, keeping pending Lossi, nothing.
No, I don't, Milord, my only intention, I also know government servant will want a DP hanging above his head, Milord. I also want.
So Lossi,
But it should not be, Milord, it should not be like they'll consider. There has to be a direction from this court because I am entitled. My friend also said.
I am also.
Consideration Lordship has seen.
I am already submitted before the honorable court there as per rule 9(5) he is entitled.
Yes,
So
yes.
Lossi may
Which is the rule, which disciplinary appeal?
Disciplinary appeal, madam. 9(5).
So Lossi may dispose of the matter, directing the authority to consider his representation.
Let's see.
Nine five.
9(5), Milord. In fact, invoking same said provision, the PO was appointed. Exactly. 4, 5.
If Lossi permit, I can read it, Lossi.
Yeah, it's
Lossi. So Lossi may, in that line, my lord may dispose of the matter, directing the authority to Lossi by operation of the rule 9(5) Lossi, and after that they have to proceed the proceeding.
Without DA, they should not proceed, Milord.
But HK does the counsel for the petition. Stop. Also heard Mr. K. Gogoi, the understanding council higher education.
I am for Lossi 1, 2, and 3 Lossi.
For the respondents, 1, 2, and 3. Stop. You are serving as an assistant professor?
Associate professor, Milord.
Associate.
Yes. Some typing error is.
The petitioner is presently serving as an associate professor in the Department of Electrical Engineering,
Yes, Milord.
Assam Engineering College, Chalupari. Stop. Where's the show goes?
Show cause your lordship will find charge sheet, page 29.
There was an accident.
There was an accident.
That particular
Person-
accident of the engineering colleges. Lossi. That part Lossi says already 1 matter principal's matter.
Which one?
Atul Bora principal. 1 matter Lossi says already here. Okay. Regarding that incident, Lossi, that night, Lossi, fateful night, the students who has lost
Milord,
their life.
actually, 6 students died in that accident, particular accident. They were traveling in a Scorpio.
Lossi says remember
midnight.
Lossi, that part.
Okay. Para. Road accident took place on 28/29/5/2023, wherein 10 students.
Six students.
Huh?
6 students.
Wherein 6 students of the Assam Engineering College lost their life. Stop. In connection with the said accident, the petitioner was issued a show cause notice on 21st of September 2023. Stop.
December.
In the said show cause notice, the statement of allegation, comma, list of documents, and the list of witnesses were also enclosed. Stop. The petitioner, you replied, isn't it?
Yes, my lord. That my reply
Replied
was
to the show cause notice on
page 45, 3/7/2024.
on 3/7/2024. Stop. Thereafter, comma, the Secretary to the Government of Assam, Higher Education Department, issued a notification on 13th of August 2024, appointing the inquiry officer.
Yes.
As well as the presenting officer. Stop. However, comma, as no defense assistant was appointed to assist the petitioner.
Okay, defense assistant was appointed on the basis of the lordship fair made by the petitioner. That is the procedure.
Okay.
Lordship.
However, as draft, comma, the petitioner by a communication dated 21st August 2024 wrote to the disciplinary authority requesting to nominate a defense assistant in respect of the petitioner. The said communication was sent to the disciplinary authority via email. Stop. By another communication dated 15th September 2024, the petitioner again requested for nominating a defense assistant.
No, from by this 15/9,
Mhm.
I suggested the defense assistant, that retired government servant. Page 72.
Suggested the name of one retired officer, correct?
Yes, my lord.
To be nominated as the defense assistant to assist the petitioner. Stop. Continue. However, as no steps were taken, the petitioner, in the meantime, comma, the inquiry officer by a communication dated 5th September 2024 set the departmental inquiry against the petitioner in motion by fixing 18th September 2024. Stop. As no defense assistant was nominated, despite making several requests by the petitioner, comma, the petitioner again submitted an application on 19/9, correct?
Yes, my lord.
19/9/2024 for nominating a defense assistant. Stop. Where's the rejection?
That rejection your lordship will find.
In the meantime, comma, the Deputy Secretary to the Government of Assam Higher Education by a communication dated 18th October 2024 informed the petitioner that the Higher Education Department regretted the proposal for allowing the nominated defense assistant by the petitioner to serve as the defense assistant in the departmental proceeding. Stop. Para. After comma, the inquiry officer again fixed 24th of October 2024 for examination of witnesses.
Yes, 24 and 25 by two communication, page 98 and 100.
After the inquiry officer fixed 24th October 2024 and 25th October 2024 for examination of witnesses with regard to the departmental proceeding against the petitioner by communications dated by both two by
Event dated, yes, 18
by
October.
two communications, both dated 18th October 2022. Stop. In the meantime, comma, the petitioner again proposed for allowing who is the person?
Page 107, Milord, Subra Mollik Chaudhuri. He is an in-service.
For allowing one Shri Supra Malik Chaudhary to be the defense assistant in the said disciplinary proceeding. Stop. The consent letter was also given by the said Supra Malik Chaudhary on which date 22/10/2024. 2024. Stop. However, comma, till date, no defense assistant as requested by the petitioner has been provided by the disciplinary authority. And in the meantime, the inquiry officer again fixed 6th of November as the date of hearing with regard to the departmental proceeding against the petitioner. Stop. Para. Learned counsel for the petitioner submits that Rule 9 within brackets 5 of the Assam Services within bracket Discipline and Appeal Rules 1964 clearly provides that the delinquent officer may request before the disciplinary authority for appointment of a defense assistant and the same on the approval of the disciplinary authority has to be given to the concerned to the said delinquent officer. Stop. However, in the present case in hand, despite request being made, comma, the disciplinary authority is not permitting the petitioner to have a defense assistant and thereby jeopardizing the case of the petitioner in the said disciplinary proceeding. Stop. Para. Mr. Gay Gogoi, London Standing Council Higher Education, in his usual fairness, submits that Rule 9 within bracket 5 of the rules of 1964 provides that if the petitioner requests for a defense assistant, the same would be given to the petitioner after the approval of the disciplinary authority. Stop. Para. This court, on the matters available on record, has found that the petitioner on several occasions had requested the disciplinary authority for nominating a defense assistant to assist the petitioner in the said departmental proceeding against him. Stop. The first request made by the petitioner was rejected on 18th of October
1810.
2024. Stop. Thereafter, comma, the petitioner again made a proposal for appointment of one Shri
Subhra Malik Chaudhary
Supra Malik Chowdhury to be nominated as the defense assistant to assist the petitioner in the said disciplinary proceeding. Stop. The records further indicates that the said Shri Supra so and so has given his consent to act as the defense assistant, where that
108, my lord.
on 22/10/2024. Stop. Para. This court has perused Rule 9 within bracket 5 of the rules of 1964. And the same reads as under, just quote it. 9(5). Stop. Para. On a perusal of Rule 9 within bracket 5 of the rules of 1964. It clearly provides that the government servant may present his case with the assistance of any other government servant approved by the disciplinary authority, but he may not engage a legal practitioner for the purpose. Stop. In the present case, comma, the petitioner has already sent his proposal for appointment of one government servant to act as defense assistant in the disciplinary proceeding against the petitioner. Stop. However, comma, what is noticed is that the disciplinary authority is yet to take a decision, and in the meantime, the inquiry officer is proceeding against the petitioner without proceeding against the petitioner, which would jeopardize the case of the petitioner in the said departmental inquiry. Stop. Accordingly, comma, the disciplinary authority is directed to take steps forthwith to permit the petitioner to allow the petitioner to have a defense assistant to assess him in the said departmental proceeding. Stop. The departmental stop till a defense assistant is nominated to assess the petitioner. The departmental proceeding against the petitioner shall not proceed any
Yes.
further from
Yes.
today. Stop. That much will do
Yes.
with the above
And
observation.
lastly, may indicate also after appointing, they may proceed. Otherwise, they will, others they will confuse Lordship.
And don't just say, needless to say,
Lordship.
that once the defense assistant is provided to the petitioner, the disciplinary proceeding would proceed accordingly.
Lordship, Lordship.
One small request, my lord. Tomorrow is the date fixed. My friend will kindly communicate to the government, my lord.
You can tell them.
Or my lord will kindly, if I can get the order, my lord.
Gogoi?
That may be recorded, my lord.
I'm not recording it. You tell not to proceed.
Much obliged. Deeply obliged.
10 of Delhi list order.
So in this case, IA number 3209 of 24, that I have filed for vacation of the stay order.
Okay.
Petitioner side is not available today.
Who's on the other side?
Mr. J.C. Bora.
Huh?
Mr. J.C. Bora.
You are Mr.
R. Soma.
IA 3209. This is for vacation.
Yes, sir.
And what is this IA of 3019?
3019, they have filed. Continue to be there. It has filed for continuation of the interim order.
Okay. But where's in the morning someone was mentioning that they filed an affidavit.
Yes.
Call for the
Current that is in the record of town.
which affidavit?
3209.
That was filed by us, Lordship. By filed.
My lord, I am appealing for the petitioner, my lord.
Ah.
My lord, he has filed and my lord, I for vacating, my lord, the interim order, my lord. So I may require 2 weeks time to file objection, my lord.
Okay, IA 3209.
One thing I have a slight objection. The petitioner is going to retire in this month. So the matter may be taken up a bit early.
The petitioner is retiring.
Read petitioner, yes, sir. Not me.
He is not related with this school, my lord. How it is related to the, my lord, headmaster of the school, my lord.
No,
A question of amalgamation, my lord. Anybody may, my lord.
No. Who's the petitioner?
Petitioner is the, my lord, headmaster and the, my lord, president of the school managing committee.
Okay, the headmaster is retiring.
Yes, yes.
But then the president is there.
Yes, he's there, my lord.
So it survives.
Yes.
Okay. IA 3209, huh?
I have my best objection on 2 things, because they do not have the locus standi. What is their case then?
So let him find the objection.
I want to place 2, 3 things.
Not required.
Think the matter bit early, Lord.
Yeah, that's why heard Mr. R. Shamalan, counsel for the applicant. Issue notice. Mr.
J.C. Bora, my lord.
J.C. Bora, learned counsel, appealing on behalf of the opposite party 1 and 2.
Yes.
Press for, I'll give you 10 days time. Press for 10 days time to file objections. Press a lot, list down, give a date after 10 days. It will be 15th.
18th.
18th.
My lord, interim order is there, my lord. That shall be continued.
In the writ petition?
Yes.
In the writ petition, list the matter on 18th. Interim order passed earlier to continue till the next.
Deeply obliged.
13.
May it please, my lord. Matter pertaining to non-payment of arrear salary to the petitioner, my lord. The petitioner initially appointed, my lord, in the year 1994 to 96. There is 9 petitioner, my lord. So 94 to 96, they.
This is a 2016 matter.
Yes, my lord.
Till now, they have not paid you.
No, my lord.
Affidavit has come. Kathania?
No, my lord. In fact, these are the matters pertains to the, my lord, illegal appointment of Sipnagar district. Subsequently, my lord, they are subjected to a screening process. They appeared in the screening process, and some of them have already been accommodated as one tutor and
Assistant.
teacher, no? Teacher, no?
Assistant.
They have.
You have filed your affidavit?
No, my lord.
No, then what is this?
But in my record,
You filed a reply affidavit
Yes, my lord.
to the,
What happened, my lord? Initially, my lord, there is a series of matter, my lord. They have filed one affidavit, my lord.
where?
these matters are
But
all
not this matter, not this matter,
all
my
are
lord.
tagged along with
All are,
similar kind of matters, my lord, but
but
subsequently
now,
just
now separate,
segregated.
my lord.
And in one of them, matter leading case, we have filed an affidavit. To that affidavit, they have
I
filed a
have
reply,
replied.
my lord. But in this particular case, we have not filed a affidavit, madam.
No, how did it got separated?
Because subsequently, my lord, most of the illegal and irregular appointees, they were participating in the screening process, and most of them have been subsequently accommodated, depending upon their qualification.
Okay.
Here also, my lord, some of them have been accommodated as assistant teacher, my lord.
Yes, my lord.
I'll produce that.
Here, my lord,
relevant information, my lord.
No, without that affidavit, I can't take up this matter.
Yes, madam. Then I will file an affidavit stating that who have been given the accommodation, madam, subsequently.
Our only grievances only for salary, my lord. They have taken our service, my lord, and no termination letter was issued. If we are irregular or illegality, no termination letter was issued. We have worked till 1 and 6 are retired, my lord, on 2019, my lord. From 2012, they have not paid, my lord. And now 2, 3, 4, 5, 7, and 8, and 9, my lord. They have accommodated as assistant teacher in 2021, my lord. It is our, my lord. And our, they are only for salary, my lord. We have worked, my lord, but they have not paid salary, my lord. And no termination letter was also issued.
Okay. Then you file your affidavit.
Yes, madam.
But Mr. M. Kalita.
Yes,
Learned counsel. Mr. N. G. Katania, learned standing counsel.
Elementary education, madam.
Elementary education is allowed
10 days, madam.
2 weeks time to file affidavit in opposition. Stop. List after 2 weeks.
Obliged.
17.
Please, Your Lordship. Worship, this matter pertains to promotion of the petitioner from tutor assistant professor to assistant professor. Worship, the only disputed fact was regarding the genuineness of the PhD certificate, Lordship, and that has been also checked, and it has come to the conclusion, and there is also a communication by the Magad University that the certificate that has been issued to the petitioner was genuine, Lordship.
May I? Okay. Regarding the dispute of their PhD certificate of Magad University, if a high power committee has constituted and her PhD certificate has been verified now. Now, after verification, it has been sent to the SLC. On 23rd September, the verification process was over. Now it has been forwarded to the government for SLC for further decision. So, I pray for 4 weeks time so that what comes out, I may place before now.
Okay, heard Mr.
W. Rahman on behalf of Mr. K. Kalita.
Okay, heard Mr. Your name is there?
No, Lordship, not in the court.
W. Raman, learned counsel appearing on behalf of Mr. K. Kalita,
K.
learned counsel for the petition. Para, Mr. A. R. Tabildar, learned standing counsel higher education, submits on instructions that
verification of the PhD has been
that the verification of the PhD degree of the petitioner has been completed.
Verification process has been.
Huh?
Verification process has been complete.
That the process of verification of the PhD degree of the petitioner has been completed,
and has been
and the matter has been submitted before the
state level committee.
Before the state level committee. Stop. He accordingly submits that once the state level committee gives its decision, appropriate orders would be passed. Stop. He therefore prays for 4 weeks time.
Lordship may fix the matter after 2 weeks, Lordship. It has already been delayed a lot, Lordship.
Can you do it in 2 weeks?
No, it will take because a number of such candidates are there.
Then let him take 4 weeks. We'll fix a date.
Otherwise, it will not be.
Praise a lot. List the matter on 9th of December.
Hello.
Obliged.
18.
I think in this matter, we need some time, Lord. 2 weeks time, maybe.
That may be fixed, my lord.
Heard Mr. N. Sharma, then the counsel for the petitioner. On request made by the builder and the Sterling Council, higher education, list the matter when, how much time?
After 2 weeks.
21st of March.
What?
21st of November.
26th. 26th.
Obliged.
Ow.